right, Ms. Blinn, can you hear us?
Good morning, Your Honor. We can hear you. Can you hear us?
Great, I certainly can.
Great, thank you. Chairman Chandler, just to give you a little bit of information, I'm in a conference room with Ms. Keaton, and we're using phone for audio, so you should be able to hear each of us equally well. I'm going to ask Ms. Keaton to say good morning, just to make sure.
Okay, so in just a second, I'll have Ms. Glass and Mr. Garcia introduce the witnesses, and at that time, I just ask if you all have camera available, that Ms. Keaton come on camera, so I know she's here.
Yes, it appears that GoToMeeting meeting is not enabling or not allowing us to turn on our camera at the moment.
Okay, we will work on that.
Okay, thank you.
All right, good morning. We're on the record in case number 2022-283, electronic investigation of Kentucky Power Company Rockport deferral mechanism. My name is Kent Chandler. I'm chairman of the Kentucky Public Service Commission and will be presiding over the hearing today. Joining me today is Commissioner Mary Pat Regan. For those in the hearing room, I please ask that you set your cell phones to silent mode, do not disturb mode, or turn them off. For our witness that will testify remotely and counsel who participate remotely, I'd ask that you mute your microphone and turn off your video if you're not speaking, to ensure, Ms. Blinn, that since you're using the phone for audio, that you make sure that the computer audio is also off. And that, most importantly, please alert the commission if you are experiencing technology failure that prevents your participation at any time. Attorneys can contact staff at the previously provided contact information. The purpose of our hearing today is to take evidence in this matter. Before we get started with anything else, we will have an entry of appearance of counsel. I'd ask the counsel for parties that have witnesses that you'd go ahead and introduce your witnesses at the time of your entry of appearance. So, starting off with Kentucky Power Company.
Good morning, Your Honor. Katie Glass of the law firm of Sykes Harbison on behalf of Kentucky Power Company. Also hearing on behalf of the company Prohot Vice is Hector Garcia Santana and Kristen Blend, who is appearing remotely. We also have with us today in the hearing room our witnesses Brian West and Heather Whitney. Testifying remotely is Allison Keaton.
Okay. All right, and Ms. Sanderson is, how does that work? Is she technically one of your witnesses?
Kenneth Tillotson is appearing to represent Ms. Sanderson on behalf of Liberty Utilities Company in the event that the commission calls her to testify.
Okay, and we have Mr. Tillertson's, well, I guess your motion to admit Mr. Tillertson's, admit him pro hoc vice. We'll go ahead and permit him to participate in the hearing today. I think before our hearing is over, the order will have been entered by that point. But that's no issue to go ahead and admit him in the meantime. All right. And just so that I'm aware, sorry, Ms. Glass, just so I'm aware, who will be introducing the individual? I know Mr. Tillotson with Ms. Sanderson, but what other witnesses will you all be, you and Mr. Garcia be introducing?
I will be introducing Brian West. Mr. Garcia will be introducing Ms. Whitney. Ms. Blend will be introducing Ms. Keaton.
Thank you. For the Office of the Attorney General,
Mike West for the Office of the Attorney General, and we have our witness Lane Collin, who we are jointly sponsoring with KIUC.
okay, and for the Kentucky Industrial Utility customers?
Morning, Your Honors. Mike Kurtz for KIUC. I think Jody Kyler-Cohn is going to join remotely, but I don't see her yet.
All right, thank you. And then finally for commission staff.
Just Heather Temple and Nancy Vensel here for commission staff.
Thank you. I noticed that on the 18th, Kentucky Power filed notice that public notice had been given on this November 16th. I'll tell you, the best part about this job is reading the classifieds that come with the public notice. So we've got the public notice taken care of. We've got Mr. Tillotson's admitted Mr. Tillotson. Are there any outstanding motions other than that motion for Pro Hug BJ?
Your Honor, we don't have any outstanding motions, but the company received the commission's order denying our motion to recuse Your Honor's, and Your Honor's letter filing concerning the same on November 23rd. The company does not intend to make any further argument at this time, but respectfully notes its objection for the record to the chairman's participation in this proceeding for the reasons stated in the motion.
Okay, and I don't know what legal effect the objection has, but certainly you're entitled to relief under the statutory provisions under 400 and 410, so,
We understand that.
thanks.
Thank you, Your Honor. One other thing, I do understand that Ms. Blend and Ms. Keaton cannot see the video of the commission room and are not able to turn on their camera.
Okay, so we'll take a short recess at this point, before we move to public comment, and we will try to fix the issue with, Ms. Blend and Ms. Keaton's video. So we will take, we'll take a recess until it's fixed. Re-optimist.
Are you able to see me?
All right, Ms. Blinn, can you hear us?
Yes.
And you can see us?
I can hear you and see you, Your Honor. I need to confirm.
That you state your name and address and then provide your comments.
Thank you. Can you hear me okay?
I think so.
Hi, I'm Angie Hatton, and I'm state representative for the 94th District, which is Letcher, part of Pike, and part of Harlan counties within the AEP's service area for Kentucky Power. And I'm grateful for the opportunity to be here to speak to you. I believe this is my 5th or 6th testimony before the Public Service Commission in my time of serving these counties in Eastern Kentucky as their state rep. And I'm grateful for the opportunity, and I'm grateful to Mike Kurtz, the attorney for the Kentucky Industrial Utilities Customers Association, for his careful and diligent work on behalf of consumers, and also to the Attorney General's office for, again, being very diligent and involving me in the process when I asked to be involved, and regardless of party lines, looking out for the public in this area. And Thanksgiving having just passed, I'm really grateful for the Public Service Commission. I'm glad that we have you here looking out for the public and being someone to whom we can turn when we need relief. And in this case, I believe that intervention is necessary in order to prevent abuse. I'm no expert in the complicated accounting that's involved in rate setting. But as a resident of the counties affected by AEP's Kentucky Power Division rates, I am one of many experts in what it feels like to not have a choice in what we pay in our electric bills, and to have to accept laws that were set into motion decades ago that protect rates of return and a monopoly for a company that charges us some enormous rates. And from recent decisions, it's clear that the PSC does have the discretion to decide not to enforce that 2017 settlement. The PSC was not a party to that settlement. And substantial changes have taken place since then, including the sale of the Kentucky Power Division to Liberty Utilities at an enormous profit for American Electric Power. And the Public Service Commission can and has the ability in their discretion to decide whether enforcing that settlement is fair to ratepayers. And that's the part I'm here to address. Eastern Kentucky has very high rates of poverty, as I'm sure you can't fail to have noticed. We pay some of the highest electric rates in the country. Second highest the last time I checked. And with the loss of coal jobs and the cost of electric power, which is very often higher than the rent or mortgage that my people pay, it is no wonder that we're suffering immense population decline. People cannot afford to live there, and there are not opportunities. Add to that situation that already existed, the recent flooding. So the human side, the public side of the argument, is that we're asking you not to return another $40 million to American Electric Power on their way out the door after all of these years of these rates. And while the $40 million to American Electric Power will be a nice additional profit that I'm sure their shareholders will enjoy, to Eastern Kentucky, that $40 million will either be another nail in our coffin if you decide to return it to AEP as an additional profit, or that $40 million to us can be one more lifeline and a financial help to us in a terrible time that might actually help us survive. So I'm grateful to have the Public Service Commission to whom we can turn to ask for help. And I request that when you make your decision, that you realize that in addition to looking out for the law and making sure that things are applied according to the law, that you also remember the human beings that are affected by these decisions and all these spreadsheets and charts. Thank you so much for the opportunity.
Thank you. All right. Seeing nobody else in the room, we had information on our website in order for folks to provide public comments virtually. No one signed up to provide those virtually. So I just remind folks, as we always do, that if anybody would like to provide public comments prior to the submission of this case, and they're watching this now or watching this after the fact, that public comments can be provided at any time before the case is submitted. A number of ways. The first of which is by email to the Public Service Commission at psc.comment@ky.gov. Again, psc.comment@ky.gov. The case number in this matter is 2022-283. We just ask that when you provide public comments, you include the case number, your name, and your address. You can also mail comments to the Public Service Commission, again, including the case number, name, and your address to 211 Sauer Boulevard, Frankfort, Kentucky 40601. And you can also provide public comments through our website. There's a particular page on our website where you can provide public comments at psc.ky.gov. All right, so given that there are no more public comments, we will move on to the presentation of evidence. Ms. Glass, since this is an investigation, was open as an investigation, although the commission required Kentucky Power to provide testimony, initial testimony on the matter, it's at least at this point in some way you can object either now or state their disagreement now or in a post-hearing pleading. But it is my reading of the case posture that Kentucky Power does not have a burden of proof in this case other than the new tariffs that Kentucky Power has filed. And actually, I don't even know if those were filed in this case or if they were filed through a tariff filing system. But I don't perceive Kentucky Power to have a burden in this case, given how it was initiated. But I do think it would be best to, and maybe you alluded to this in the fact that we were talking about who was going to introduce what witness, to follow the ordinary procedure that the commission follows, even in cases in which the applicant has the burden of proof or the utility has the burden of proof. So my preference today and tomorrow, if it goes there, is for you all to introduce and tender witnesses and then to conduct cross-examination, first with the AG, then KAUC, commission staff, commissioners, and then give you all an opportunity to conduct redirect, and you all can introduce the witnesses in whatever order you would like to. I do think we would have an interest in hearing from Tisha Sanderson, so we can get through the Kentucky Power witnesses and then move on, bring Mr. Tillotson up. But does anybody have an objection? First, does anybody disagree with me? If you do, this is the time to stand up and jump. But second, do you all have an objection to that process today?
No, we don't, Your Honor.
Okay. Mr. Kurtz, Mr. West?
Process.
No
issues?
objection.
Okay, all right. All right, so it'll be you first, Ms. Glass. You can call your first witness.
Yes. Kentucky Power Company calls Brian West.
Mr. West, please raise your right hand. Do you swear or affirm that the testimony you're about to give is true and correct under penalty of perjury?
I do.
Please have a seat. State your name and address for the record.
My name is Brian West. My address is 1645 Winchester Avenue, Ashland, Kentucky, 41101.
Ms. Glass?
Mr. West, can you please state the name of your employer and your position?
Yes, I'm employed by Kentucky Power Company as the Vice President of Regulatory and Finance.
And did you cause to be filed into the record of this case direct testimony, responses to data requests, and rebuttal testimony?
I did.
And do you have any changes or updates to that testimony or those responses?
I do not.
If I were to ask you those same questions today, would your answers be the same?
They would.
The witness is available for cross-examination.
Mr. West?
Yeah, just a few. How are you doing, Mr. West?
Very good, Mr. West.
Just a few broad questions to kind of set the stage, if you will, but the Rockport fixed cost savings are an amount of money that are currently in base rates related to Kentucky Power's participation in Rockport, correct?
Yes. Are you asking if there are some savings in base rates?
Yes.
Sure. Yes.
Okay.
Yes.
And the settlement agreement in 2017 and the order approving at least a part of that settlement agreement set up a process to take those costs out of base rates after Kentucky Power no longer participates in Rockport, right?
Yeah, the settlement agreement addressed how to handle those Rockport fixed cost savings.
And how much, what's the amount of annual fixed cost savings related to Rockport?
I believe my exhibit to my direct testimony, I think it's Exhibit 3, showed that the amount in base rates is approximately $40.8 million.
And so this case is largely about what to do with that $40.8 million, correct?
Well, it's not simply about that. It's also about the other aspects of the settlement agreement. You know, the Rockport, the estimated Rockport offset and the true up in 2024. You know, in addition to, you know, collecting the $57.9 million deferral over 5 years. So certainly that is a piece of it.
So you
Yes.
mentioned the estimated Rockport offset. Can you describe what that is?
Certainly. Let me turn to the settlement agreement, if you will. And I'm looking at page 7 of the settlement agreement. Pages 6 and 7, actually. At the bottom of 6, and I'll just, for the record, the Rockport fixed cost savings shall mean the annual amount of non-fuel, non-environmental Rockport UPA expense included in base rates for rates effective in November 2022. The estimated Rockport offset shall mean the amount of additional annual revenue the company estimates would be necessary for it to earn the commission authorized return on equity for 2023, considering the termination of the Rockport UPA and the Rockport fixed cost savings. The actual Rockport offset shall mean the amount of additional annual revenue that would have been necessary for the company to earn the commission authorized return on equity for 2023, considering the termination of the Rockport UPA and the Rockport fixed cost savings. The company shall calculate the actual Rockport offset using a comparison of the per books return on equity for 2023 to the commission-approved return on equity. The actual Rockport offset cannot exceed the Rockport fixed cost savings. And finally, the Rockport offset true-up shall mean the difference between the estimated Rockport offset and the actual Rockport offset.
Okay, so for the estimated Rockport offset, in your testimony, you provided a value, an estimate, did you not?
I did, sir.
And what amount was that?
I believe it was 22.8 million, and that was based on the 12 months ending June 30 of 2022.
And the effect of designating that amount, the estimated Rockport offset, is that money will flow back to Kentucky Power, correct?
That's correct.
So if you take the 22.8 from the 40.8 million. That leaves about 18 million left, correct?
Yes, right, of the 40.8, yes.
So what will happen to that 18 million under your proposal?
Well, under the 2017 settlement agreement approved by the commission, it was contemplated that it's possible that that 18 million, in this case, could be collected in the 2024 true-up, all depending on what happens in 2023 on a per-books basis. Now, it could be more, it can't be more than that, right? It's capped at 40.8, so we know that. And the settlement was clear when it said the actual Rockport offset cannot exceed the Rockport fixed cost savings. So it clearly contemplated the possibility that that could happen, you know? It also could be, depending on how 2023 comes out, that, you know, it could cut the other way and there could be a refund to customers of the 22.8. It all depends on 2023, and the settlement was clear in that it is supposed to use the authorized return on equity for 2023 per books.
What do you think is the likely result? Where do you think the $18 million will end up going? Will it go to ratepayers, or will it be collected by Kentucky Power?
I really can't speculate on that. Like I said, I don't know how 2023 is going to come out.
But there's a possibility that the entire 40.8 million will be retained by Kentucky Power. Is that correct?
There is the possibility. There's also the possibility that part of it could be refunded.
I don't have any other questions.
I have a clarification before we move on to Mr. Kurtz about your response. When you said it was clear about the 2023 ROE per books, I'm paraphrasing your response. Were you referring to that it's clear it's 2023 per books, or it's clear it's the 2023 authorized ROE?
Well, it's the 2023 authorized ROE, but that's compared to the actual per books performance of the company in 2023.
Yeah. Well, I'm asking what clear, I guess what clear relates to there, the ROE to be earned or the per books calculation to earn the ROE?
I think they're both clear.
Okay, so what ROE?
The ROE would be 9.3%, which is what is currently authorized for Kentucky Power.
And you think that's clear in the 2017 documents?
I think it has to be assumed that it would be the currently authorized ROE for the company.
Well, I don't mean to split hairs, but it's hard to, it's either clear or it's assumed. I don't know that assuming something is necessarily clear.
Oh, okay, I understand what you're
That's
saying.
why
I understand.
If it's clear to you, because I didn't read your testimony as saying it was clear to you, you were saying it only makes sense. I think that's on like your rebuttal testimony, you discussed this issue. Do you think it's clear it should have been the most recently authorized, or you just assume it makes the most sense for it to be the most recently authorized? I just want to make sure I'm clear about your position on that, because it didn't seem like your answer was in line with what the testimony is. So let's take a step back.
Yeah.
I just want to, it was your answer earlier, the clear refers to the per books. Is that fair?
Yes.
Okay. Can you, before we get to Mr. Kurtz, then talk about the ROE for just a second? The actual, you said 9.3. I want to make sure that, what is the basis for your position that 9.3 is the appropriate ROE?
Okay. The basis for it is that was the authorized ROE that was approved in the 2020 base case, the 174 case. Will be the authorized ROE in 2023 prior to new rates being set on 1/1/24 with a new authorized ROE. So during 2023, in my mind, it makes sense for us to use the currently approved authorized ROE of 9.3%.
Okay. All right, I'll wait till it's my turn. I just wanted to make sure so I can ruminate about it before it gets around. So thank you,
Okay.
Mr. West. Mr. Kurtz?
Okay.
Thank you, Your Honor. Good morning, Mr. West.
Good morning.
The total amount of Rockport fixed cost savings is $50.8 million on an annual basis. Is that correct?
It's 40.8 in base rates and a $10 million amount that's collected through tariff PPA.
So that's 50.8 total?
That's correct.
Okay. And the 10 million collected through PPA will automatically go to ratepayers beginning a day after the unit power agreement expires on December 8th or 9th?
That's right. It would drop out.
Okay. And of the 40.8 million, all of that will go to ratepayers in December of 2022, starting in December 8th, correct? The
That-
22 days or so of December, ratepayers will get all of the proportion of the 40.8 million.
That's my understanding, yes.
And when new rates are set on 1/1/24, also ratepayers will get 100% of the 40.8 million fixed cost savings that are currently in base rates, correct? Because there will be a cost that will no longer be incurred.
That's my understanding, yes.
Now, the Liberty transaction is scheduled to close in mid-January, is that correct?
Yes.
Okay. So between January 1 and the closing of the transaction, let's just use January 15th as an approximation. Between
Okay.
January 1 and January 15, whatever the commission does in this case with respect to the 40.8 million, that will be absorbed or retained by AEP prior to closing.
Well, AEP will still be the owner of the company at that point, so, yes.
Okay. And then from January 15th, assume that's to close through the end of the year of 2023, it will be on Liberty's shareholders for whatever the commission does.
I believe so, yes.
Mr. West, independent of the 2017 partial settlement agreement, do you have an opinion about what a just and reasonable allocation between the shareholders of AEP, Liberty, and the ratepayers, what a just and reasonable allocation of the 40.8 million would be independent of the 2017 agreement?
My opinion would be that the 2017 settlement was approved by the commission and settled by the parties in the case, except for two parties that were not signatory to that agreement. The AG, I believe, and the KCUC did not sign, but it was negotiated and entered into by the other signatory parties. So my opinion would be that rules.
Okay. My question was independent or disregarding the 2017 agreement. Do you have an opinion about what a just and reasonable allocation between ratepayers and shareholders would be of the 40.8 million?
I do not.
I'm going to talk about the deferral for just 1 minute. Over a course of 17, 18, 19, 20, 21, about 5 years, 50 million of Rockport costs were deferred by Kentucky Power. Started out at 15 million a year, and then it tapered down to about 5 million.
That's correct. The total was 50.
Okay. And with interest, that balance stands at about 59 million?
I think it's 57.9.
Okay, 57.9. And so As long,
Yes.
and your proposal is to recover that over 5 years, again, with a return at the company's weighted average cost of capital?
Yes, that's what the settlement says.
Okay, and so that would be about a $13.5 million repayment over 5 years of the $50 million deferral, correct?
I haven't done the math on that.
If Kentucky Power receives its weighted average cost of capital on the deferred asset, then Kentucky Power's earnings are unaffected, correct?
We're talking about specifically, it's just the deferral, right?
Yes.
Just collecting the deferral. It's a cash flow.
I understand that there's a cash flow issue, but on an earnings basis, there's no effect on the company's earnings, correct? As long
That's
as you
my
can-
understanding, yes.
Okay. So, would you agree the company is made whole other than cash flow if it gets its $50 million back with interest at the weighted average cost of capital?
I don't know that I would agree with made whole, because the settlement agreement goes into the Rockport offset. And that was part of the agreement for the company agreeing to do the deferral in the first place and provide those benefits to customers over the last 5 years, was that we be allowed not only to collect the Rockport deferral, which are FERC-approved rates, but to collect and earn, just in '23, the company's authorized ROE. That's also a point to this.
The customers got a $50 million reduction in rates over 5 years, but customers are paying interest on it at the full weighted average cost of capital, correct?
That is per the settlement agreement, yes.
What is tariff CC?
I believe it stands for capacity charge, tariff capacity charge.
And that has been in effect since 2004, correct? When the
Yes.
Rockport agreement was extended?
Yes, and it expires on December 8th of this year.
And the current amount of that on an annual basis is $6.2 million?
I think that it was 5.8 in
It started at
2020.
that, but it's currently
Well, I
at
think it's
6.
5.8 in 2022. It did, there was a time when it was like 6 or 6.2, but I think it's 5.8 per the tariff. I'd have to look at the tariff.
Okay, I guess that's a matter of record. I assume it's 6.2, but since 2004, oh, and by the way, the tariff CC is money that Kentucky Power earns below the line, correct? In other words, it's not reflected in the revenue requirements as a reduction to revenue requirements in a rate case.
I subject to check. Agree.
Okay. Would you agree that since 2004, customers have paid $105.7 million in tariff CC, which is money below the line that is not an offset to revenue requirements in a rate case?
Again, I haven't done the math on it, and I guess I would remind you that these were approved by the commission. These are approved rates by the commission.
Do you know what return on equity is built into the Rockport Unit Power Agreement as established by FERC?
I don't know it off the top of my head now.
Does 12.18% sound familiar?
It sounds familiar, yes.
Why hasn't Kentucky Power sought to reduce that rate of return at FERC ever?
I do not know, sir.
How long has Kentucky Power been on notice that the commission is going to take an independent look at the allocation of the Rockport fixed cost savings?
I think it was mentioned in the order to the 2020 base case.
So that would be January 13, 2021.
Yes, and I think it might have been mentioned again in the rehearing order on the February 22nd?
Yes, it was. Thank you. Good memory. So, would Liberty have been on notice about those orders prior to closing on the sale on October 26, 2021?
Objection, Your Honor. Mr. West is not testifying on behalf of Liberty and has no knowledge of what Liberty knows or not.
I'll rephrase. What was the world on notice on October 26, 2021, that the commission had 10 months earlier, 8 months earlier, said that it was going to take an independent look at the fixed cost savings issue?
Well, the orders are public record, so I guess anyone in the world that chose to read them would have been on notice.
Do you think it would be fair to assume that that fact was factored into Liberty's agreement to pay $2.846 billion in October of last year for Kentucky Power?
I have no idea.
The order opening this case was September 2, 2022, correct?
That sounds right.
And again, the commission put Kentucky Power on notice that the fixed cost savings was going to be independently reviewed, independent of the 2017 agreement.
I believe they said they would review it, yes.
And about less than a month later, on September 29, was the first amendment to the stock purchase agreement between Liberty Utilities and AEP. Is that correct?
That date sounds right.
And in that amendment, on September 29, 2022, the sales price was reduced by $200 million from $2.846 billion to $2.646 billion, correct?
Objection, Your Honor. I'm going to lodge just a standing objection to any questions about the sale to Liberty. It's not relevant to this case, and there's no reason to be bringing it up.
Well, the reason I'm bringing it up is because during 2023, whatever the commission does in this case will, after closing, be on Liberty's, will be, Liberty will either get the benefit or the detriment of that. And the point I'm trying to establish is the sales price, the original sales price of $2.8 billion, as well as the amended sales price, reducing it by $200 million to $2.6 billion. Liberty knew or should have known about that this was a risk that was factored into the sales price.
So I'll overrule the objection if for no other reason than this sale of Liberty has been, I think, discussed at length in both discovery and in Mr. West's rebuttal testimony. So I would keep it narrow and keep it relevant only to the issues in front of us, Mr. Kurtz.
So when the original sales price was entered into, as well as the amended sales price, Liberty knew about that this case would be happening. Do you agree with that?
It's possible that they knew that, yes.
Chairman, no further questions.
Mr. West, I apologize. I've been a little under the weather, so if you can't hear me, just let me know and I'll try and yell. If you could look at your rebuttal testimony, page R6, the table 1.
Yes.
Could you please explain whether the net incomes shown include storm restoration expenses that were deferred as in case 2022-293?
The storm expenses should not be included because they were set up as a regulatory asset and not expensed. I would defer to witness Whitney to verify that, though.
Okay, so ask that for her as well. Okay. And then if you could also look at the third request for information, item 1, attachment 1.
The commission's third request?
Yes, the response.
This was 3-1?
Yes, and then attachment 1.
Okay.
Could you also explain whether the net incomes shown in that table include the expenses that were removed for rate making in 2021-74?
Well, that's what this is trying to represent, is it's taking the things that were disallowed in the 2020-174 case and trying to estimate what those would be in 2023. So it was trying to replicate the same items and estimate what those could be in 2023.
Can he do it? So would you be able to make those same kind of adjustments for the net incomes in that rebuttal testimony table 1?
Would I be able to?
Yes.
I guess I would point out that 2023 hasn't been through a rate case yet. It's not even certain that these same things would be disallowed in a future case. So the question of yeah, I can do math, but should we is another question.
Well, I think we will request that you do the math as a post-hearing data request.
Okay.
And then, if there was a cost that had been approved, but then turned out that it was not fair, just, or reasonable, are you implying in your testimony or your rebuttal testimony that the commission could not then alter that?
Well, I guess what I'm implying, and maybe more so than implying, but saying, is that, a settlement agreement is a contract, and it's entered into by parties to mitigate risk and provide certainty. And once that happens, people rely on that. The company relies on it for, strategic planning and forecasting. Financial institutions rely on it in the same manner. If you come back then and say, no, we have to change this, it sets a dangerous precedent for any future settlement agreement by any utility in this entire state. And I guess that's where my position lies, is it should be honored as the commission has already approved it. That's my position.
Staff doesn't have any other questions.
Commissioner Regan?
No, I don't.
How long have you been in Kentucky, Mr. West?
Since February of 2019.
So I guess I'm confused again between the answer that you just provided, not to me, to Ms. Dibble, and your rebuttal testimony. Because your rebuttal testimony specifically discusses adjustments that can be made after 2023 has occurred to take into account expenses incurred in 2023 that otherwise shouldn't be recovered from customers. How do you square your rebuttal testimony on that issue with the answer that you just gave Ms. Temple?
Can you point me to where you're referring to in my
Well,
rebuttal?
sure, I mean, it's only 13 pages of rebuttal, 14 pages of rebuttal, but it's rebuttal 11, where your response is that Mr. Collins seems to argue that it may be too difficult to calculate the offset true-up if it needs to be adjusted for various elements related to the sale to Liberty Utilities Company. To the contrary, the commission and the parties to this proceeding are sophisticated, knowledgeable, and capable of working through much more complicated issues than those presented with respect to the company's 2023 earnings, which are merely matters of addition and subtraction.
Okay, I got you. So what I'm talking about is really two different things. What staff had asked about were, can you estimate things that, in 2023 that were disallowed from the 2020 case? And my point there was that they may not be disallowed in a future case. So are they appropriate or not to make? I can't say at this time because they've not been through this commission and through a full review.
Well, whether
What
they're
this-
appropriate is not the company's prerogative, right? The determination as to what rate should be included, what cost should be included to determine rates is left to the commission, correct?
I understand that, sir, but I'm saying that it hasn't been through a rate case yet. There hasn't been evidence presented that would show this should be allowed, not disallowed. So I don't know that I can say whether it's appropriate right now, today, or not.
So Ms. Temple's question was about whether you take the perspective that whether they can or cannot be adjusted after the year has occurred. Can be.
But they can be, yes.
Okay, what her question was, is do you object or do you take the position that they can be done in 2024?
They can be, and maybe at that time, well, if we file a case next year and we have rates effective 1/1/24, we should have an order, at the end of December, and we would know then whether these things had been ruled upon or not,
Well, it's my understanding, I mean, I've seen enough said publicly, it's my understanding that expectation a year from now, that the case in front of the commission is most likely going to be based on a forecasted test period. But what we're talking about here is going to be 2023 expenses, correct?
Yes.
So if it's based on a forecasted test period, none of the historical cost of 2023 should be ruled upon in a forecasted test period rate case beginning January 1, 2024. Would you agree with that?
Well, this will be our first forecasted test year if we file it that way. So I admit I'm not up to speed on all of the rules for filing a forecasted test year.
Okay. So you are aware, though, of the rules related to a historical test period rate case, right?
Yes.
Okay. And so there's I want to get it right, the exhibit Kentucky Power, I think, R KPSC 3.1 Attachment 1, which is the entitled Expenses Projected to be Included in Kentucky Power's 2023 per books income that had been disallowed by the commission. Are you aware of that Excel spreadsheet? Just generally.
Yes.
Okay. It has 7 lines, SERP and EEI, and I'm not going to go through them.
Yes.
But all of those are adjustments that were made by the commission. Would you agree?
Yes, they were.
But that does not include expenses that were removed by Kentucky Power for rate-making purposes in the company's application. Would you agree?
There were some expenses that were excluded, yes.
Okay. But they're not included here. Would you agree?
That's correct. I don't believe they are.
And so I'm just going off the top of my head, I'm working my way down 5001 section, I think it's 26. But advertising expenses, certain advertising expenses are non-recoverable. Would you agree?
That's right. Those were removed.
Okay. And then certain business expenses
That's correct.
and charitable contributions.
That's correct.
Okay. So just so I'm aware, it's your all's position, it's your position through your testimony, that those expenses at whatever level they're incurred would be used to calculate, it, just by definition, are used to calculate per books in 2023, correct? Insofar as they're incurred?
Well, I guess I would point back to the settlement agreement that talks about GAAP net income, which is a defined term. And I think that was why it was used in the settlement agreement, was to say that, you know, all of these adjustments, whether they're appropriate or not, it's much simpler to just point to a net income number, a GAAP net income number. It's like, everybody knows where that is on the balance sheet, right, or on the income statement. You know where that number is. It's defined. It's the same for each company.
That, all of that being the same, the black and white of the settlement agreement speaks for itself. I'm just wanting to make sure that I understand, you would agree that advertising expenses, all advertising expenses that are incurred by Kentucky Power during the calendar year 2023, all business expenses, all charitable contributions, all of those would be included in that calculation of net income, correct?
They would be, yes.
Okay. And that would include, like, if there's a departure of an employee from Kentucky Power in 2022 and a severance package was provided, is that ordinarily included in the calculation of net income?
I would defer to witness Whitney on that question.
And how about, do you know if there's a settlement in a legal dispute, whether that would be recovered or reflected in net income?
I'm not sure.
Would that be something you think Ms. Whitney would know?
It's possible, yes.
You've talked today about what 2023 looks like. Well, that no one knows what 2023 is going to look like on a net income basis, right? If any of us did, if any of us could see into the future, none of us would be here right now, right? We'd all be in the stock market
That's right.
or playing the ponies or something else, right? So none of us have insight into what 2023 is necessarily going to look like in terms of a net income basis. But you would agree that the utility, in large part, is in control of a significant, let me rephrase that. The company is the only entity that can affect its fortune, right? That you all write the checks, you all send out the bills, you all have discretion in certain expenses. Would you agree?
We do, but we're not immune to the effects of 100-year ice storms or floods or, extraordinarily mild temperatures that are out of our control.
So I'm glad you brought up that, because that's exactly what I was wanting to ask about. In 2022, you all had expenses in which the commission deemed to be appropriate for deferral accounting. Is that right?
Yes, they were storm expenses.
And they were based on the category of they were extraordinary and non-recurring expenses. Is that your recollection?
Yes.
Okay. If you didn't get deferral accounting for those expenses, they would be used in that calculation of net income under GAAP. Is that right?
They would have been expensed, yes.
And they weren't, had the commission denied deferral accounting, that would have been a reduction in the company's earnings in 2022 because it would reduce net income. Just by definition, would reduce the company's earnings, right?
That's correct.
In 2023, if you have a extraordinary non-recurring expense that in 2022 you might have sought deferral accounting for, because it would reduce your earnings, what impetus is there in 2023 for you all to seek deferral accounting for those same types of extraordinary non-recurring expenses?
Well, the company produces quarterly financial reports that are, reviewed by many, institutions, the street, the market. I don't think we would want to take any kind of a significant number to the bottom line when we had the opportunity to defer it as a regulatory asset per this commission's approval. I'm not sure why I would make that kind of a decision.
Well, because it's gonna be recovered with, under your all's proposal with the fixed cost savings, right?
I guess I'm not sure how to answer that. I would follow the same rules that I did in 2022 and seek a regulatory asset.
Right, but even if it's, I mean, the reason you sought a regulatory asset in 2022 is because of the extraordinary non-recurring nature of the expense and the hit to your bottom line had you had to expense it in that year, right?
But those are the same things that would happen in '23. They're
Right,
the
but
same
you have-
reasons I would seek a regulatory asset.
But the latter is not at issue, right? Because it's going to be offset by the fixed cost savings.
Yeah, but I would not look at that like that. I would not say, oh, well, I'm gonna get it through these fixed cost savings, so why bother with a regulatory asset? That's not how my thinking works on this.
Right, is
If
it
it's
your
a
call on
non-recurring-
that?
Pardon?
Is that your call? I mean, you're giving us your opinion, that's great, all you can give us is your opinion, unless you have something already written in stone, that's a corporate policy, but is it your call whether to seek deferral accounting at Kentucky Power?
Largely, yes.
So, we've got the reg asset. Starting December 9th, I think, you all will no longer be incurring expenses under the Rockport UPA, is that right?
That's my understanding, yes.
Okay. I did some, quick math, and that's about 22 or 23 days, out of a year. And the Rockport savings on an annual basis is $40.8 million. That's the amount that's in base rates, right?
That's right.
So if we annualize that 22, 23 days, that's close to $2.5 million of the 40.8. Is that your understanding of the amount that will pass through tariff PPA to reflect that stub period of the remainder of 2022 for the savings from the Rockport UPA?
I haven't really done that calculation. I'll assume that you're correct on that.
Okay, but I mean, that would be the way to do it, right? Is that however many days are left in 2021, that as a percentage of 365, and then just multiply that times 40.8 would be the way to figure out what sort of savings is gonna occur from at least the amount that's in base rates, from that stub period. Is that?
That sounds correct, yes.
And the reason I ask is, I'm trying to figure out whether the savings come about on like a daily basis, a monthly basis, every quarter, every 6 months, or on a yearly basis. Like, do you all, let me ask this, the tariff CC, did you all recover that's previously 6.2 and then the annualized or the taking out the last 22 days is 5.8 this year? Did you all recover that from customers on a monthly basis, on an annual basis? How did you all calculate that? Do you know?
I believe it was on a monthly basis. It was set annually, but then it was recovered monthly.
Okay, and then the 40.8 amount that's in base rates, are those things that are billed to Kentucky Power from, maybe I&M, I forget who technically you all send the bills to for the Rockport UPA, but are those paid for by the company on a monthly basis?
I'm not sure how that accounting works, whether it's done monthly. That sounds correct, that
Okay.
it would be.
It's not like a end of the year invoice and you just, you write a check for $40.8 million, right?
No, I don't believe so.
So the proposal is to pass, how does the let's say, how does the amount between December 9th and December 31st get to customers?
It would be part of the calculation for the tariff PPA, and it would just flow through in the demand portion of tariff PPA to customers.
Okay, so, but does that mean that that 2.5 is then spread out over all 12 months of 2023 through tariff PPA?
I believe that's how it would work,
Okay.
yes.
And then the 40.8 is spread out over 12 months in tariff PPA
Yes.
as the passback?
Yes.
And then the 10 that's coming through PPA today just ceases to exist, is that right?
That's right. That's right. And other things like that are in the FAC or the ES that are related to Rockport, they drop out too.
Cease to exist.
That's right. Those are savings to customers immediately.
So, well, the savings to the company, which just get reflected as a direct pass-through as a savings to customers,
That's right.
right? Okay.
That's right.
So, but though, let me ask this, does tariff ES, is it on a lag? Is it on a 2-month lag or a 1-month lag? I remember it saying something about for expenses incurred in this month.
Yeah, I think the capital lags maybe even 3 months, but it is on a lag.
Okay, so that won't show up until into 2023 for that to drop off, is that right?
I think so, yes.
So the 40.8 is being passed back monthly through tariff PPA, but that makes sense because that's kind of how it was paid. You think you were billed something fairly monthly of those fixed charges, right?
I believe so.
Okay. The 2.57, although it relates exclusively to that December time period, is going to be passed back probably over an annual amount or a monthly amount over a year. And then the 10 million was passed through monthly, but it's just going to cease to exist monthly. But the new thing, new in the whole situation here, is this credit amount. The $22 million credit amount that's going to be an offset to tariff PPA, or I guess an increase to tariff PPA for what you all think today your shortfall is going to be in 2023. Is that right?
Yeah, the 22.8 is just an estimate. And at the time that I filed my testimony, the most recent data that was available was ending June 30 of 2022. So that's the period that we picked. That's how the calculation was done to get to the 22.8. In my rebuttal testimony, if you look at, I believe it's R6, that staff had asked about, if you took the period at the end of October of 2022, the number goes to 36.5 instead of 22.8. So it's like whatever, you know, there's a lot of variability month to month on ROE and quarter to quarter. So it easily could have been in my testimony at 36.5.
I'm not picking the number. I just want to make sure 22.8 is the number, right? And that's that the proposal is to effectively flow it through tariff PPA so that the monthly charge through tariff PPA is 22.8 divided by 12, and that's what customers are being proposed under your all's proposal, proposed to be charged through tariff PPA each and every month through 2022. Is that right?
That through 2023.
2023. Excuse me.
Yes, that's correct.
Okay.
As an offset to the savings.
So what's the basis for that proposal?
The basis for the proposal is the 2017 settlement agreement that defines what the estimated Rockport offset is.
Well, hold on a second. You're saying that the 2017 proposal said in there that there would be a credit during 2023 reflecting the estimated shortfall in 2023?
Yes.
And then, does the settlement discuss the true-up?
Yes, it does.
So your proposal is to do a credit, an estimated credit at the 22.8 throughout 2023.
Yes.
Whatever the shortfall is up to the 40.8 would be included as a true-up at some point in 2024. Is that right?
Yes, in fact, the settlement was pretty specific about that. On page 8, it says by February 1st, 2024, the company shall file an updated purchase power adjustment factor under tariff PPA for rates effective March 1, 24. This filing shall only reflect the impact of the Rockport offset true-up on the purchase power adjustment factor. The purchase power adjustment factor shall be established to recover or credit the Rockport offset true-up amount in 3 months.
Okay, so you've got the true-up in 2024, and how is that then recovered? Let's say it's 10 million short under your all's proposal. So it'd be a 32.8 total, right? 22.8 got recovered, let's just say perfect recovery, but you were total 32.8 short in 2024 under your proposal.
Okay.
Over what time period is that 10 million recovered?
It says over 3 months, so I would assume, it says rates effective March 1, 2024, so March, April, and May of 24
Okay.
is what it says.
3 months.
Yes, sir.
Okay, so we got 10 million through tariff PPA, the 40.8. Environmental surcharge disappears at some point next year, is that right?
It's early next year, yes.
Okay, and then there, under your proposal, when does the deferral regulatory asset begin? When does the company, let me ask it this way, when does the company start recognizing amortization expense related to the deferral regulatory asset under your proposal?
It should start on the same day, on the 9th of December, and be amortized over 5 years.
Okay, you say should, I mean, you all have requested amortization to begin on that date?
Well, the settlement agreement says that it should begin on that date.
Okay, what's the amortization expense on a monthly or daily basis that you are proposing? You're proposing it to be over a 5-year period, right?
That's right.
So is it going to run from December 9th, 2023 until, or December 9th, 2022 until December 9th, 2027?
I think Witness Whitney may be a better witness for that question, sir.
And your proposal is to recover the amortization expense through tariff PPA?
Yes. Per the settlement agreement.
What about with rates effective January 1, 2024, which, you know, the 2020, I think, rate case presumes a subsequent rate case with rates effective January 1, on or near January 1, 2024. Would it be your expectation that that amortization expense would then be recovered through base rates?
I'm not sure. It could be. It could continue in tariff PPA as it was approved in the settlement agreement.
So I want to go back to the question I was asking at the outset. This true-up process. You were talking in your rebuttal testimony about taking issue with Mr. Collins' testimony. Line 12 on that page, line 12, page 11, your rebuttal.
Uh-huh.
You gone through and it's my characterization, but you would take an issue with his position that it was unreasonable for him to argue to throw out the use of 2023 because of this issue of the subsequent transaction, right? The sale to Liberty.
That's right.
And instead, everybody is sophisticated here, and then you go on line 12. That's a fair characterization of your testimony. I just want to skip through eight lines before that if I can.
That's right.
The line 12 though, you say, tell me if I read this wrong. The items related to the sale to Liberty Utilities Company noted in the company's response to AG KIUC 2-9 should be addressed to the extent necessary in the 2024 Rockport offset true-up filing.
That's
Is that-
correct.
Okay. So you're not necessarily, and this is what I didn't understand to your response to Ms. Temple.
Okay.
You're not necessarily objecting to subsequent adjustments in the true-up to those expenses that were incurred in 2023. Your objection is to include them in the estimate, in the calculation of the estimate for the credit to exist during 2023, or the offset to exist during 2023.
I think it would be taken into account in 2024, but there would be, certain adjustments that would be appropriate for 2023.
Yeah, so forget the appropriateness of any individual adjustment, right?
Okay.
Well, it's been said that Mr. Madison does not plan on staying with Kentucky Power post-transfer. Mr. Madison's the president. If he wrote himself a severance package for, a crazy amount of money, you're not saying that the commission's, it's not your position that the commission's hands are tied from doing anything about a transaction cost in 2024 as part of the true-up. You're just saying the appropriateness of any adjustment should wait until then. Is that fair?
Yes.
Okay.
Yes, and what, my main concern with Mr. Collins' argument is just to say, well, nobody knew about this sale, and it's too difficult, just far too difficult to ever figure it out. Might as well just use another period. And my point is that I think that, we're smart enough to figure out what we need to do after we see what the actual results are for 2023. Companies get bought and sold all the time. These are planned events. These are, we know what's going to happen, to a certain extent, and we can deal with it in 2023. That was my point, is we don't need to make that decision now. We can make it in the true-up in 2024, when those numbers are known.
That's helpful. I want to ask just if you have any information. I mean, the Kentucky Power's FAC this past month has been about as high as I've ever seen it. As a general matter, if you have physical capacity, that as long as your physical capacity is able to dispatch and produce energy at or below the marginal cost that you can buy it, LMP, that's a physical hedge on energy prices for customers, right?
It is, but have you seen the rising coal prices? Even with using, own generation, it's tough with the rising prices.
Well, I've seen rising spot prices. I have, but I just.
Oh, even the contracts are.
But the marginal price, LMP reflects prevailing fuel prices for the most part, right? Coal and gas. Would you agree?
Mostly gas, I think, yes.
Okay. So, as a general matter though, having some sort of physical hedge is better than not having any at all. Would you agree?
I would agree.
Okay. And starting in a week and a half, for at least a certain amount of megawatts, the company will not have a physical hedge against energy prices, correct?
No, but I mean, not owned by the company, but we will have a contract with current affiliates through May 31st of '24 for the shortfall in megawatts.
Well, it's shortfall in megawatts, but that, well, let me ask it this way. Do you have access to those megawatts for energy purposes at some sort of marginal cost?
Not for energy, it's for capacity.
Well, but that's what I'm asking about, the FAC, right? FAC is about energy, correct?
Yes,
Okay, so
Yes.
you're going from paying a lot, maybe it wasn't a lot back in the late 90s, early 2000s, it's a lot today, a lot for capacity under the unit purchase agreement, but at least you have the energy from those resources today, right?
we do, but it's my understanding that with being a member of PJM, that we buy all of our energy back after it's sold into the market.
That's right, but you're gonna have less energy to sell. You're only going to be buying for the amount of shortfall you now have.
That's right.
So right now, today, you have enough capacity at any time to create more energy than you use, right?
I'd have to look at the numbers, but I think that's correct.
Well, I mean, you guys are purchasing less replacement capacity in the next 2 years following the expiration of the UPA than you currently have under the UPA.
That's right.
Okay, you're long until December the 9th.
That's right.
Okay. And then December the 9th, you are, I guess, adequate for purposes of PJM's FRR requirements in terms of capacity, right? You're purchasing only exactly what you need to in those delivery years, is that correct?
That's right.
For purposes of the FRR plan, right?
Yes. And the
But
reserve margin.
you don't get the energy from those facilities that you're purchasing the capacity for in the FRR plan, right?
I don't believe so, no.
Okay, so in the event that in any given moment, you are buying more power than you can generate with your own assets, you are just buying more from the market than you're able to sell, right?
I think so.
I mean, you can only produce if you can only produce 100,000, that doesn't make any sense. In terms of generation resources that you get the right to the energy from, you're going to have less of those than what your peak demand is, right?
Yes.
Okay. And so, in the event all of your resources, or the most expensive resource you have, let's say coal goes back to $150 like it was last year, right? And that's what you all are paying, and your most expensive unit becomes Mitchell, and it's $125 a megawatt hour, right? If LMP is below $125, then you're able to buy it cheaper than you can produce it, right?
In that scenario, yes.
Okay. If prices are $500 and you guys are able to produce exactly the amount you need, or you sell all, you buy back, but it's the equivalent, you all effectively only end up paying $125, right?
I think that's correct.
Because you made $375 for the amount that you didn't need. You're getting back. It's a physical hedge, like we talked about earlier, right? You shouldn't ever pay more as long as you have enough to cover your own demand. You shouldn't ever pay more than what your marginal price of electricity is, even if power prices are high. Is that your understanding?
I guess I wish I would have studied the intricacies of the fact a little bit more for today. I'd really like to refer to, or do a post-hearing data request.
Well,
If
but
that's the best way to answer
so-
your question.
Let me be fair to you, Mr. West. I know the answer to all these questions. My concern is about what the rate-making implications of all these issues are, right?
Okay.
You're going from getting out of a Rockport unit power agreement where you have the right to both the capacity and the energy,
Yeah,
to this bridge agreement where you only have the right to the capacity for purposes of meeting your FRR plan, but that you have no right to the energy produced by any of those assets. Is that your understanding?
that's my understanding, yes.
Okay, so in the event, we know you're short because you had to buy capacity through the purchase agreement, right? Through the bridge
The bridge PCA.
right, in order to meet your FRR plan obligations. We know you're short. And so in the event there are sustained high energy prices, even if all your generation produces power, your customers are subject to those sustained high energy prices in a way they were not before, right?
They could be, yes, it's possible.
Okay. And does Kentucky Power have a plan to address that issue?
I think that will be addressed in our IRP as far as in the longer term assets that are proposed to be added to the portfolio.
Well, just me speaking, it should have been addressed in the last IRP, but the IRP is a plan, right?
It is.
But what happens in 2023, the entire year 2023, do you all expect to have more generation that could produce energy other than Mitchell and Big Sandy 1?
It's unlikely, especially if you're talking about building something, but if it was a PPA, that's relatively easy and quick to do.
Well, nothing's in front of us for a PPA,
I understand that.
right?
But there could be.
Right, okay. You could walk in tomorrow with it. That you're the masters of your own, you're the captains of your own ship on that front, right?
Right.
But the reality is that there is a physical hedge today for all of your demand, and for dozens of megawatts, there won't be a hedge post-December 9th, a physical hedge post-December 9th. Even when that hedge has been in place, even when these physical units exist, you all are seeing all time, or maybe not all the time, but you all are seeing higher FAC rates to customers than you all have seen in years, right?
That's right.
So do you have a concern for what happens to the FAC and to customers' bills when they've already been high with the hedge, as to what happens when the hedge goes away?
I do have a concern, and, you know, right now, the two plants that we have, you know, half of Mitchell and Big Sandy, are down for maintenance. This was mentioned, I think, in the recent FAC that we filed on the Monday of Thanksgiving week, I think a week ago today. And they're down for required safety and maintenance issues, so that when those prices spike, which we expect to happen in January and February, the plants will be in, you know, good working order and they will be running. So that's part of it.
That's part of it, but shoulder months don't seem to exist anymore, right? I mean, some of the highest rates I've seen come through before this last one, through your all's PPA, were last September, reflecting of cost last September, October, November, which are ordinarily shoulder months. Is that your experience too?
I see what you're getting at with the prices being high and everything, even during the shoulder months, but you have to take the plant down sometime. And it's better to do it during a historical or traditional shoulder month than it is when you expect it to be really high in January and February.
Yeah. Do you all, I mean, you were talking about budgeting and finances earlier and dependence on commission orders. You provided an exhibit that looked specifically, I think it may have been a rebuttal exhibit, that looked specifically at what you think the net benefit of the reduction in the UPA fixed cost savings will be through 2025. Do you remember that?
Right, yes.
And there was a line in there, I think that's your BKW one, R1, excuse me, your rebuttal Excel exhibit. And I think it's a nominal amount. Yeah, it's just a nominal. You have a nominal savings on B12 of a net impact of the fixed cost savings from January 2023 through May 2025 of $180.8 million. Do you see that?
I do.
So I wanted to ask about the fuel adjustment clause. So a couple of questions. One, on line 19, it says it doesn't reflect any changes from any base case filing or proceeding after 2017-179. Do you see that?
Yes.
Is that supposed to be 2017-179 or 2020-174?
I think it was intended to be 2017 because
Okay.
that, is the case that we're talking about.
Well, that's fine. I just wanted to make sure that I understood, like the true up there is reflective of what you all think your costs are going to be in 2023, right? And this is looking at some of these 2023 expenses, but like your ROE is different in today than it was in the 2017 case. And there, I guess I don't understand what line 19 is supposed to mean. If it doesn't take into account any change to operate, I mean, does this include the net income that was reflective or expected to be in the test year of the 2017 case?
No, I think all we're looking at here is what we expect are the Rockport costs through the fuel adjustment clause that won't be there anymore. And it's an estimate.
Well, it has to be an estimate. We've talked about that earlier, right? Again, you and I wouldn't be here if we knew.
That's all this is.
We'd be somewhere else. The fuel adjustment clause line. It says the analysis does not reflect an estimate for any potential future additional energy purchases required to meet load to replace Rockport energy.
That's right.
So going back to your earlier response, though, you were saying, look, we sell all, we offer it economic, if it dispatches, but otherwise we just buy it LMP, right? That's what you said. Is there an acknowledgement with that statement that you have an expectation that there are going to be more costs for replacement energy as opposed to the Rockport energy?
It's saying that that's possible, and we didn't take that into account because we don't know what those costs are going to be.
Right, but you all have an idea of what those costs are going to be, right? I mean, you all subscribe to Platts and all of these other I have signed off on orders granting petitions for confidentiality related to forecasted energy costs, or you all have an idea, a consensus idea of what things are going to be. Why not at least try to take that into account to provide that greater stratification of estimates?
I guess we could, but you're talking about, an estimate of fuel costs, an estimate of coal costs, an estimate of what people are going to use, the kilowatt hours they're going to use. I suppose you go back and do like a 3-year average or something on those months, but you're talking about, a huge guess there that could be close, it could be way wrong. So I'm not sure what the benefit of it would be.
Well, I think that's for the commission to determine, right?
That is, I'm just saying that's a big guess. Where you're just multiplying a bunch of estimates together.
Well, and the reason I ask is because, the commission's order in the 2020 rate case, and I think even on rehearing, spoke to the position around, or the interest around the amortization period of the regulatory asset, right? I think it specifically spoke to whether replacement costs are higher, it might make more sense to extend the amortization period as opposed to maybe if replacement costs were smaller, it might make sense to have a shorter amortization period. Do you remember that in those orders?
I do, sir.
Okay, and replacement capacity is only one consideration of the replacement of the generation, right? The energy is the other component of what the replacement units cost, right?
It is.
And your all's estimates have accounted for the capacity side, but you would agree have not accounted for the replacement energy.
They have not, as I said,
Okay.
very big guess.
The 22.8 million, I think this is my last question, Mr. West. The 22.8 million. I'm gonna be a little flippant here. Would you agree that the 22.8 million shortfall for the time period, we'll call it a shortfall, that's fine, we're on the same page about what that means?
I think so.
Okay, so the 22.8 million shortfall for the period ending June 30, 2022, you would agree that that doesn't happen on a equal monthly basis in order to equal an annualized $22.8 million?
I'm not sure.
Well, like,
actually.
each month's books end, it's not, the shortfall, right, is not 1/12 of 22.8 each month. It gets bigger, does it usually get bigger, the shortfall of earning your approved ROE? Does it usually get bigger as the year goes on? Because there have been more capital additions and things like that?
I suppose it could, and maybe that example I gave in my rebuttal testimony shows it, that if you looked at October, the shortfall is 36.5 million.
Right.
So, and it, you know, at any month in there, it's up and down.
Well, that's what I want to make sure that we're clear on. It's not a normalized amount each month, right? It's not going to be the same level.
No, it was the data, the best data we had available at the time that I filed my testimony.
Okay. Do you all have an expectation that given your testimony, you have an expectation that from June it's 22.8, October it's 36, and you have an expectation at the end of 2023 it's going to be in excess of 40.8, right?
Well, it can't be in excess of 40.8.
No,
that's
the
cap,
shortfall can, but you can't.
It could be.
But you all expect it to be. That's your testimony, right? You expect the shortfall to earn your ROE to be in excess of the entire 40.8 credit amount.
No, I wouldn't say that. I would say, and I guess if you look at the exhibit that we were just looking at, where, you know, we did put in the $6 million for 3 months out in March, April, May, right? And that was represented as to be a worst-case scenario. That if 2023 doesn't come out really good for us, then it's certainly possible that the $18 million, you know, that gets up to that 40.8 would be required in order to earn the ROE. That's worst case scenario. I'm not saying that that's fully what we expect. I'm saying that that is a possibility and it could be different.
Then let me just ask, what do you expect?
I don't know.
Well, I mean, you all know what your capital additions are going to be throughout 2023. You know what's going to go in service in 2023 and what additional what you plan to do in 2023. And you know what the depreciation expense of those assets in service are going to be, right?
Well, at this point, I believe the budgeting for 2023 is not yet final. So I don't really know.
Okay. You all have 5-year capital plans, right?
Do we have a 5-year?
AEP has a 5-year capital plan, right?
I think so.
Okay, you all at at Kentucky Power, do you all have a 5-year capital plan?
I assume so, but I have not seen it,
Okay,
honestly.
all right. So my question at sum is, why does it make sense for the 22.8 to be recovered from customers equally throughout the year if it would seem that the shortfall gets bigger as the year goes on? You're recovering
Well,
money from customers that you may not have necessarily had the shortfall yet in that month, right?
That's true, but it's all trued up. I mean, in 2024, it's going to be, like I said, it's trued up, whether we require additional funds to earn the ROE, or the 22.8 was more, and then there's a refund to customers. I mean, that's how about everything works.
Right, but there's a time value of money component to that, right? I mean, that's why the deferrals get a weighted average cost of capital, right? Because there's a time value of money component to a cash outlay.
That's right. You have to finance those costs.
Well, not just finance those costs, but customers have a time value of money component, right?
They do. I suppose everybody does.
Right. That was the point of my question. Everybody has a time value of money. And
Yeah.
and maybe internally, people have a different value they prescribe. The commission sets what it expects shareholders' time value of money to be, at least on an equity investment, right? So, but it's you guys are getting on a monthly basis, or you're proposing to receive on a monthly basis, cash of $22.8 million divided by 12 months, each and every month through tariff PPA, right?
Yes.
Okay. And then if it's 10, the proposal is to pass back the other 12.8 over the 3 months in 2024, right?
That's what would happen.
On a nominal basis, right?
I think so.
Okay. And the same goes the other way around. The 18 million, the 22.8, whatever, all on a nominal basis, right?
Yes.
All right. Told you that would be my last question. What I really mean is line of questions. Thank you, Mr. West. It is already 10:53. Ms. Glass, let's take a 17-minute recess. I'll let you talk to your witness, and then we'll come back to you for redirect.
Great, thank you.
All right, we will take a recess until 10 after 11. All right, we're back on the record in case number 2022-00283. Ms. Blinn, can you confirm that you can hear us?
Thank you, Your Honor. We can hear you. Can you hear me?
I can, thank you. Ms. Glass, do you have any redirect for this witness?
Yes, just a few.
Please proceed.
Thank you. Mr. West, earlier, when Mr. Kurtz was asking you some cross-examination questions, the chairman had a couple of questions for you. And essentially, and if I'm misstating or not paraphrasing you correctly, Mr. Chairman, please correct me, asked for support for your statement that the ROE for the Rockport offset is the currently authorized ROE for 2023, where that is clear in the 2017 documents. Do you recall that line of questioning?
I do.
Okay. Do you have the 2017 settlement agreement in front of you?
Yes.
Would you mind to turn to page 6 of that at the bottom?
Yes.
And could you read the definition of the estimated Rockport offset, please?
Yes. Estimated Rockport offset shall mean the amount of additional annual revenue the company estimates would be necessary for it to earn the commission authorized return on equity for 2023, considering the termination of the Rockport UPA and the Rockport fixed cost savings.
Thank you. And could you read the first sentence of that next paragraph for the definition of the actual Rockport offset?
Yes. Actual Rockport offset shall mean the amount of additional annual revenue that would have been necessary for the company to earn the commission authorized return on equity for 2023, considering the termination of the Rockport UPA and the Rockport fixed cost savings.
Thank you. And the company's currently authorized ROE after the company's last base rate case in 2020-174 was 9.3%, correct?
Yes, that is correct.
Thank you. Okay, later on in Chairman Chandler's questioning of you, he was asking essentially, what incentive does the company have to seek deferral accounting in 2023 when there is the Rockport offset available? Do you recall that?
I do.
And you testified, and I'm paraphrasing, that the company would treat that instance the same way it would in 2022 when there is no Rockport offset, correct?
Yes.
So would you also agree that regardless, there's not a bottomless well available to the company for the Rockport offset?
That's correct. It's capped at 40.8 million.
Finally, the chairman had some questions about the timing of recording amortization expense. Do you recall those questions?
I do.
Do you think that Ms. Whitney could address the chairman's questions on that topic?
I think so, yes.
Thank you. Those are all the questions that I have. Thank you.
So the only thing I have, Ms. Glass, and if I could, just for a second, I'll be perfectly honest, I still do not understand what happens with everything between December the 9th of this year and December the 31st. And in particular, I mean, you all have made a tariff filing on November the 15th related to changes to tariff PPA, right?
Yes.
And in that calculation, it refers to the 40.8 million. And the 40.8 million is the annual amount of the Rockport fixed savings, right?
Yes.
How is the, let's call it 2 or 2.5 million of savings between December the 9th? I mean, I know the tariff goes into effect December the 9th, but how does that amount from December the 9th to December 31st, how does that get included and as a offset? How is that taken into account if only the annual amount is included in tariff PPA?
And I'd have to look at our filing a little closer to see how the math was done on that.
Okay, so I'll just say, I'm gonna make a statement. I do not understand how the amortization expense, no, strike that. The amortization expense is like a daily calculation. Ms. Whitney and I can talk about the amortization expense in a second. I don't but I don't necessarily understand how the amortization, how the expenses and the savings for the stub period, which I mean to be we're back to stub periods like it's ADIT, but the stub period between December 9th and the end of this year, how those are taken into account in tariff PPA, given that tariff PPA is charged on an annual basis, and at least the savings, fixed cost savings, are provided in the tariff on an annual basis. So, that's a statement. I think that it may be of interest if you can take maybe at lunch or the remainder of the hearing, if you could take a look at that tariff, and maybe we could recall Mr. West, just so he could familiarize himself with the tariff provisions that are provided in that tariff PPA. Because I think that would be very helpful to all of us, because it's not clear how that's taken into account holistically in that tariff PPA proposal that I think has an effective date of December the 9th. Which, well, that's a different matter, but it's, directly relevant to this. Ms. Glass, do you have anything on that?
I do not, but we can do what Your Honor suggests.
All right. Are there any additional questions for Mr. West?
No, sir.
All right, thank you. We'll let you step down and I guess see you at some point in the future, near future. Great. Ms. Glass, would you all like to take Ms. Whitney next? Is that correct?
Yes, company
Okay.
calls Heather Whitney.
All right, Mr. Garcia Santana.
Thank you, Honor.
All right, Ms. Whitney, please raise your right hand. Do you swear or affirm that the testimony you're about to give is true and correct under penalty of perjury?
I do.
Okay. Please state your name and address for the record.
My name is Heather Whitney. My address is 1 Riverside Plaza, Columbus, Ohio, 43215.
Mr. Garcia Santana.
Thank you, Honor. And your position and by whom are you employed, Ms. Whitney?
I am Director Regulatory Accounting Services for the American Electric Power Service Corporation.
Thank you. Did you provide answers to discovery requests, data requests, in this case, either on your own or jointly with other witnesses?
Yes, I did.
For the portions of the responses that you were responsible for, were those prepared by you or under your supervision?
Yes.
Do you have any changes that are required to those answers at this point?
No.
Your Honor, given that Ms. Whitney doesn't have testimony, I think that would complete submitting her testimony in this case.
She does not, I think, responses to data requests, do you intend on conducting any direct examination of Ms. Whitney?
No, Your Honor.
Okay, thank you. Mr. West?
It's standard for cross-examination.
Thank you.
No cross for this witness.
I do, thank you, Chairman. Ms. Whitney, were you here for Mr. West's testimony?
Yes,
Okay, and he deferred a number of accounting questions to you?
that's right.
Okay, I want to ask you about the 2024 true-up case, where that is where you will figure out how much extra of the 40.8 million that the company's entitled to, depending on actual earnings in 2023 versus the forecast, which was the shortfall as of June 30, 2022.
When Kentucky Power reaches that point, yes, that data will be available to perform that calculation.
Okay, how, as a general matter, how are you going to eliminate all of the Liberty-associated transition costs from 2023 actual earnings to develop what the shortfall is, but for the Liberty acquisition?
Right now, the basis that I would have for doing the true-up calculation would be the 2017 settlement agreement that was reviewed and approved, and that simply specifies use of per books. If there were an alternative framework, it would have to be laid out, and there is no such framework at this point. I would do the calculation as is laid out in the 2017 settlement agreement.
Well, do you recall the chairman asking Mr. West about everybody's sophisticated here and we can change the 2023 actuals if need be. How would you, what would need to be done to change 2023 actual financials to make a calculation or get a determination of the return on equity as if the Liberty transaction did not occur?
I think to take your question apart, there are a lot of presumptions or looking into the future that I would need, that would need to be done. And I can't do that right now. Number one, I think we also provided in the discovery responses to let you all know that, the purchase accounting will be performed by the Liberty Utilities team. I'm not familiar with the purchase accounting entries or how the accounting transactions that will be recorded post transaction. In order to suggest or be familiar with, how to propose adjustments, I would need to be familiar with that type of information to look at what was actually recorded in 2023. But all of that is moot given the current language in the 2017 settlement agreement.
If the commission wanted to effectuate the intent of the settlement, let me ask you this, in 2017, do you think anybody envisioned that AEP would sell Kentucky Power and that the transaction would close in 2023?
I don't think that people regularly can, we can't predict the future. There's a lot of things that have happened, the pandemic in 2020. There are a lot of things that we didn't envision happening in the future. So it could be one of the many things that we did that are not foreseeable.
Do you think this 2024 true-up to look at 2023 actuals and make adjustments, do you think that will be a simple case or quite complicated, akin to a mini rate case in the first quarter of 2024?
I think it depends.
Thank you, Chairman. No more questions.
Yes. Excuse me. I think also that was referred to you from Mr. West was as a post-hearing data request, can you make the rate-making adjustments to the net income that was found in the rebuttal testimony, Table 1?
We could prepare an adjustment to net income based on the estimates that are provided there. Yes, I agree with what Mr. West said, that we can do that math and prepare that adjustment.
Thank you. And I don't have anything further.
I don't. So those adjustments, do you know if those adjustments are specifically the ones the commission made in the final order, or the commission made in the final order and the company proposed in its application?
They are simply the adjustments that the commission made in its final order.
Okay, but like all the accounts that by definition the company puts below the line for purposes of a rate case would not end up in those calculations?
That's correct. They wouldn't be in there.
So like charitable, so you do accounting AEP through the entire AEP enterprise or just the AEP East companies?
I support various East and West companies.
Okay. Are charitable organization costs recovered in any other jurisdictions that you can think of that you work with?
The FERC Uniform System of Accounts defines a specific account that those items should be recorded in, and typically those particular accounts are not included in cost of service calculations.
Okay.
So
So like even when you file for formula rates at FERC, right, that costs are presumed to be prudent unless otherwise deemed not prudent, those accounts are specifically excluded for rate recovery. Is that what you're saying?
yes,
But they show up in the net income calculation, is that right?
that's correct. And per books, net income, they're included.
So I'll ask about the amortization expense. You've reviewed the orders from the 2017 rate case?
Yes.
So have you all gotten any statements or positions from your auditors that you all already have authority to begin amortizing the deferral regulatory asset?
regulatory asset amortization matches collection and revenue. So once this commission approves recovery of the Rockport deferral, you know, if or when a recovery period is specified, that will tell me the period over which the amortization should occur. And what that means is theoretically, you have revenue coming in, you have an amortization of expense coming through your income statement, it nets to zero. There's no net income effect.
So I agree, the matching, the IRS says they ought to match and that's all fine, but what I'm asking is, do you have the order in hand that you feel comfortable saying that you can begin amortizing those regulatory assets?
We have not begun amortizing the regulatory asset, no.
No, I mean, you haven't yet. I'm saying, do you have an order in hand that you can show an auditor that to you?
No.
Okay. Is there an issue with the fixed cost savings credit, the annual credit of $40.8 million will flow through tariff PPA. The $10 million amount that's already in PPA related to Rockport will just be taken out of the calculation. Starting at the date the commission says the regulatory assets will be amortized, you will begin realizing amortization expense, right?
When the commission approves recovery, there will be an amount, a cost baked into tariff PPA that will result in a revenue. Kentucky Power will have dollars coming in the door.
Right.
When that begins, then I will begin amortizing the regulatory asset.
Okay. The corresponding revenues, because that's required under the ASC, the accounting rules, there has to be a corresponding revenue for those, for that amortization expense. In your expert, I mean, you do this every day. I just pretend, I joke, it's not a joke, I dropped accounting 2 twice before I finally saw it through a semester. But bear with me. There has to be a offsetting revenue, or an offsetting, revenue. No, there has to be something to offset that regulatory asset when you begin amortizing it, right?
I think about it the other way.
Okay.
The revenue comes first, like collection is allowed.
Okay.
So as collection is allowed, then you recognize the expense that you had been waiting. You deferred, and you're waiting and recognizing the expense as it's being collected in rates.
And that goes all back to the probable recovery and the accounting rule. Okay, great. So in this instance, if, let's just say, the amortization expense begins on December the 9th, and it's recovered through tariff PPA, what is the realized income that offsets the amortization expense for the deferral regulatory assets?
Are you asking what is the net income effect?
No, not the net income effect, but there has to be, you're now incurring amortization expense. You have to, in order to follow the accounting rules, you have to also realize some sort of income to revenue to offset that amortization expense. What is, specifically for this very specific regulatory asset, what is the genesis or the source of that offsetting revenue?
Tariff PPA. Baked into the rate for tariff PPA will be a level of amortization. In the tariff filing that Kentucky Power recently made, you'll see that level baked into the annual rate.
And that's what I want to make sure it's clear of, that it's not necessarily that the fixed cost savings are being used to cover it. The fact that it's being reflected in tariff PPA is a rate approved by the commission. As long as that amortization expense shows up as a rate to be recovered, it complies with the accounting rules, right?
That's correct, yeah.
Okay. And so if tariff PPA is a net credit or a net cost to customers, doesn't matter, as long as there's a line item in it to calculate the amortization expense, or to recover the amortization expense for the regulatory asset. Is that
That's
fair?
correct. I'll look at the elements that are in the tariff PPA rate.
Okay. So, are you aware of the tariff that Kentucky Power filed to recover the amortization expense, or the new tariff PPA that was filed to be effective December the 9th?
Yes.
And did you include that? I mean, have you, in reviewing it, does Kentucky Power include the amortization expense for the regulatory asset to begin on December the 9th?
I believe it was included. I believe it reflects, and subject to check, an annual level of amortization. Tariff PPA is a per kilowatt hour. The rates are designed to collect the revenue requirement on a per kilowatt hour basis. So it'll, as customer load, as customers use energy, the rate is designed to collect or refund, the individual elements.
Okay. The amortization expense is an annual amount, right? That's what you just said. So is it going to then be, does tariff PPA take that annual amortization expense and recover it over 387 days? Or does it take 387 days of amortization expense and recover it over 387 days?
I think I would need to see the filing. Now, if I recall correctly, tariff PPA rates are on a June to June, or maybe July 1 to June 30 rate year. So Kentucky Power has an annual filing that's mid-year. We need to look I did review the filing, but I'm having trouble recalling to that level of specificity. Because I think, to your point, I don't know if the rate is designed to just get us through that June 30th time period, and then come the next annual filing period, we'll get, the July 1, 2023, the next 1 year period. But, so to answer your question precisely, we need to look at the details of the filing.
Yeah, and I think it may even be a September 1. For some reason, I feel like the filing occurs in August, but we can.
It does, but I think it uses a historical
Okay.
period.
So I'm kind of asking because I want to make sure that I understand what we're talking about in terms of recovery of costs over certain time periods. But if tariff PPA, there's a true-up, part of tariff PPA's calculations is truing up the previous stuff. But if there's amortization expense that the utility incurs, let's say, okay, perfect example. Let's say the utility, Kentucky Power, incurs amortization expense from December 9th until December 31st, and then a full 6 months, let's just say it's 6 months, from January 1 until June 30th. Okay? That's the expense you incur if the amortization begins on December the 9th. You all actually realize the non-cash depreciation expense. But if the tariff is set up to recover only the 6 months of amortization expense and not that stub period, do you know whether it's allowed, reasonable, proposed to recover through that true-up the amount of depreciation expense that was realized but not recovered?
So as a part of tariff PPA, there's a provision that permits true-up. And so what that means is our accounting team does what we refer to shorthand as over-under accounting, where we compare rider revenues that came in to actual allowed costs or credits required, to go into the calculation. And we compute that over under recovery to make sure that all and only allowed costs are recovered. Because very rarely does the revenue coming in match the actual expenses incurred, and it's that true-up process that ensures we get back to the right place. And so that accounting occurs on a monthly basis.
But does it matter that the unrecovered depreciation expense was from the previous calendar year?
No.
Okay.
I mean, ideally, that's part of the rate setting process, is you want to set your rates, you use the best information that you have, but you never achieve perfection. There's always a need for a true up. To attribute that true up to a particular time period, you can't always do that. How do it could be that it related to the last few days in June. It might not have related to the prior December. It all depends on how there's no defined methodology for that. I think you might, when you think about prior year, current year, it's an over-under collection, that we're doing true-up accounting on a monthly basis and keeping track of what amounts are owed to or from customers so that it's fair.
So the decommissioning rider is effectively a big regulatory asset that is, its expense is amortization expense, the recovery of it, right? I mean, there are costs other than the regulatory asset there are costs included in that decommissioning rider that are other than the Big Sandy retirement regulatory asset. But as a general matter, the cost included there are amortization expense. It gets trued up in a very similar way. Do other jurisdictions have pass-through tariffs that reflect exclusively or reflect amortization expense in them? Is that something that other jurisdictions have?
Yes, this happens, yes.
Okay.
I mean,
And then finally, the $40.8 million is the amount that's in base rates today. Okay. I asked Mr. West the question earlier about where the amortization expense and the credit, it's going to be through tariff PPA until, well, it's proposed to be exclusively through tariff PPA. Mr. West's answer was that's what's in accordance with the settlement agreement. Is there an issue with, to your earlier question, is there an issue, what's the distinction between including amortization expense in base rates versus including amortization expense through the rider?
from an accounting perspective, there is no distinction. We follow the decisions of the regulatory commission that
Okay.
decides upon the recovery mechanism. So if you decide it should be recovered through base rates,
Right.
then the amortization, is in the base rates. If it's in a rider, the amortization relates, relates to the rider.
Okay. So you seem to, by Mr. West's answer, deferring some answers to you, probably have a better grasp of Mr. West on the different accounting codes or accounts that relate to a few of these items. I asked him about cost to settle lawsuits, like a settlement with a lawsuit. You've already answered with charitable contributions, and we've had a good conversation about regulatory assets. So I just want to talk, if any of your entities are involved in a lawsuit and settle that lawsuit with a payment to a different party, does that show up in the calculation of GAAP net income, or is that excluded for GAAP purposes?
Any expense that requires accrual underneath generally accepted accounting principles would be in the calculation of net income, always.
Okay. So Mr. Kurtz's questions made me think about different expenses that Kentucky Power might incur as a result of the transaction with Liberty. And so I want to make sure that that's the same case for those expenses. So like branding. You've been around AEP for how long? How long have you worked for American Electric Power?
Since 2008.
Okay. So there may be trucks that say Ohio Power Company, Ohio Power, an AEP company, Kentucky Power, an AEP company, right? Indiana and Michigan Power, an AEP company. Signs that say that, Kentucky Power, an AEP company. Shirts that say Kentucky Power, an AEP company, right? We have it with Louisville Gas and Electric and KU. They all say LG&E KU, a PPL, PPL company, right? In the event in 2023, Kentucky Power incurs expenses relating to the change in branding, those would be, there's no opportunity for GAAP accounting as like a one-time transaction expense to exclude that from GAAP accounting, right? That's going to be included in the calculation of net income.
Of course.
Okay.
I mean, we recognize all expenses.
Well, the second part of that though is it clearly delineated? So charitable organizations, right? So there's FERC accounting, there's GAAP accounting. For FERC accounting, you have the different accounts, and you know which are, I'm going to use the terms above and below the line, right? Recoverable for cost of service and not recoverable for cost of service. For GAAP accounting, that distinction doesn't exist. Is that right?
That's correct.
Okay. And you you can reconcile GAAP to, I assume you can reconcile GAAP to FERC accounting, right?
Yes, and you can also then, in rate making, in a test year cost of service, there are pro forma adjustments that do that walk. That's the purpose.
Right. Well, and so if like charitable contributions has a specific FERC account, and for like rate making, you're reconciling those so that it's like energy, it's never created or destroyed. They have to equal both at the end of the day, the numbers are going to equal for GAAP and FERC accounting. It's just whether they're recoverable for cost of service purposes, right?
Right. I think of it as we keep our books and records in accordance with GAAP and the FERC uniform system of accounts. And then we go before regulatory bodies for rate setting purposes. And each of those regulatory bodies has either directives or conventions that tell us how we should prepare our cost of service calculation. And we follow those directives and conventions in the context of a base case.
And why I'm asking this is because the question was asked earlier about how difficult or how easy it would be, to Mr. West's point in his rebuttal testimony, to do this after the fact review of certain types of costs. And specifically in his testimony, he was talking to those costs related to the transaction that might be incurred in 2023, could be subsequently reviewed in the 2024 true-up. You were here for that testimony?
Yes.
Okay. And so I'm just trying to get an idea of how hard it would be to identify those on a FERC account basis and then clarify how that relates on a GAAP basis.
So the adjustments, so if we think about Kentucky Power's last base case and the listing of, 30 to 50 adjustments that were sponsored in that case, that's fairly significant in length. Those adjustments, the other thing I wanted to give you an appreciation for, and the reason I mentioned the list, some of them are FERC account driven, but others are not. They're more conceptually driven. Where they could be in multiple accounts. We use other chart fields to be able to identify other attributes in our general ledger system to kind of identify these items, work orders. So some of them are FERC account driven, some of them are not. The data is in the company's books and records. Obviously, we prepare the adjustments for a base case.
Okay. So my last question on this front, I do think this is all I have for you, Ms. Whitty. That list of 30 to 50 adjustments, it was more than a page. I know that. It has things like charitable contributions and business expenses, which are things that are required to be removed under the regulations. But then it also excludes items for rate-making purposes that are recovered through other provisions, right, through other places in the law. So it removes FAC costs, which I assume for GAAP purposes are included, right?
Correct. Both the revenues and the expenses would be reflected in net income, which should be roughly zero, but
all these surcharges, the capacity charge, tariff PPA, all of those are rate-making adjustments that are on that list of 30 to 50.
That's correct.
Right. And so all of those individual tariffs have their own individual rules about what the terms of each tariff as to what is recoverable and how it's recovered, right? But it doesn't matter what tariff revenues and expenses are run through for GAAP purposes, right? It's just revenues, expenses, revenues, net income, right?
Correct.
Okay. And so what I want to understand is if a tariff, like tariff PPA, runs from, let's say it runs from July 1 until June 30, okay, and has a true-up provision. If at December 31, it's running $10 million behind, is that $10 million going to be used in the calculation of GAAP earnings in 2023 for the purposes of the offset?
When you say running $10 million behind, does that, I believe that means you're saying it would be 10 million under collected?
That's right.
That would mean there would be a regulatory asset on Kentucky Power's books. And that expense, the reason the regulatory asset exists is because Kentucky Power would have had 10 million of real expense, but it wasn't being collected in rates. So when we do our over-under accounting on a monthly basis and we compare revenues to expenses, we would have had 10 million too much. And we'd say, oh, this tariff has a true-up provision. It's permitted to be trued up in the future. And that allows me to reduce expense by $10 million and increase and record a regulatory asset for future recovery. So that under collection is not in the calculation of net income.
So you all have blanket approval for all of the formula tariffs like that to create regulatory assets between tariff filings?
Tariffs that permit true-up, that have provisions that permit future true-up, implicit in, you know, that establishes that future recovery is probable.
Okay.
There's a pattern of that occurring. You know, there's all the,
So FAC, our fuel adjustment clause tariff,
correct.
if you have a high expense month, the 2-month lag between when you're incurring that and able to recover it, you create a regulatory asset for those.
That's right. That expense, the difference, does not, it's, our income statement is neutral to those over-under recoveries.
Okay? And that would be the same with like, I'm trying to think here. Okay. Is there anything else that you all recover through a tariff, another tariff, that okay. So tariff FAC, or the fuel adjustment clause tariff, specifically says what it is, what is allowable to be recovered and what is not allowable to be recovered. For instance, and the law says, law is what it is, I'm characterizing here, but as a general matter, non-economy energy purchases are not permitted to be recovered through the FAC.
Okay.
And those are defined as being, it's a ridiculous definition, I'm not gonna restate it, but it's the name is, it's about along the lines of the name, non-economy purchases. And it's this whole, since Kentucky Power doesn't have a CT, it's related to a fictional unit or a fictional cost. So if it's unrecoverable through a tariff, even though it's defined by a tariff and it says it can otherwise be recovered through base rates, if it's in excess of the amount in base rates, it would be recovered under this true-up in 2023 if it's incurred, subject to the $40.8 million cap, right?
Any expense that is incurred in accordance with GAAP would be recorded.
Even if it's not recoverable under a tariff. Just because you incurred the expense, it would be included in the GAAP net income. That's what I want to make sure I'm.
That's correct.
Okay.
Yep.
I just want to make sure that I'm clear on this. So under the company's proposal, on December the 9th, it will include in tariff PPA an amortization expense related to the deferral regulatory assets, and will include a passback of the annual $40.8 million amount, $40.8 million fixed cost savings, right?
That's correct.
Well, I'll come back to you or come back to Mr. West on what happens for that, as opposed to that annual amount, what happens for the amount that, the savings and the amortization expense in that December the 9th amount. But does it really matter in the sense that the amortization expense and the fixed cost savings and every other expense that flows through tariff PPA is going to be calculated on what it ought to have been, then compared to what was actually recovered, and then any over and under of that's just going to be trued up anyways? Is that accurate?
The true-up is accurate. And the other, so to take your question apart for a second to make sure I know which part I'm answering. The part about the December 9th through the 31st, if you agree a new rate is going into effect that reflects the $40.8 million credit and an annual level of amortization, then that's the mechanism for how that will immediately begin flowing to customers on December 9th. So I agree with, so just to clarify that point, but then your latter point about how the true-up would work and how that will make sure that customers get all and only the amount of the charge that they should, that is correct. I agree with what you said.
Okay. And so I just want to make sure I understand the exercise that you all go through for calculating the over and under, is that you look at it on basically a cost of service basis and said, this is what tariff PPA should have recovered between December the 9th and June the 30th. This is 6 months plus the 22 stub days of amortization expense, the 6 months plus the, if this is what the commission says, 6 months plus the 22 days of the $40.8 million fixed cost savings, the FERC, OAT, LS, PJM, FERC, OAT, LSE expense, all the other costs that come through that should have been recovered over that period, how much was actually recovered, and then the difference is used in the true-up line on the going forward tariff PPA rate. Is that right?
The part that's throwing me is when you're saying 6 months plus. So if I may, I can describe what we'll do in December.
Well, I want to know what you all do. You said it runs, you think, through July 1 through June 30. That's what that's where the 6 months is coming from.
Okay.
So up until the end of this year's tariff PPA, and then it stops, and I assume a new calculation is run to determine over and under, and then you have a going forward tariff PPA. Is that not how it's done?
Not exactly.
All right, so can you explain to me
Yes.
what's going to happen when the current tariff PPA ends? You need to figure out the true up and then figure out a going forward rate.
So setting all of this aside for just a second, just plain vanilla over and under accounting
Okay.
that's been ongoing for tariff PPA. Each month, we pull all of the eligible costs that are eligible to be recovered. So, there's several, right, there's a
Can
few
we just
things.
pretend there's one,
Yeah, sure.
like the LSE owed expense,
Yeah.
100% above and below the base rate amount?
So
Okay.
I just pull for the listed the sub-accounts that those expenses are recorded in, we pull the actual expenses that were recorded in that month. So let's use November 2022. We pull actual November 2022 expenses that were booked to the ledger. We looked to our customer billing system and we pulled actual revenues that were collected through tariff PPA in November. We compared revenues to expenses and there was a difference. And let's just say it was $5. And let's say we under recovered $5 in the month of November 2022. Through October 2022, we had a cumulative over recovery of 10. So let's presume that. So we had a cumulative over recovery of 10. In November, we under recovered 5. So at the end of November 2022, we had a $5 over recovery. Did I say that backwards? $5 over recovery.
$10 over recovery in October, $5 under recovery in November.
So we're down, so through November, we're at $5
Over.
over recovery. Can't think and talk at the same time. So in the month of December, we'll do the same thing. We do every month, we march forward. So in the month of December, the first 8 days, we'll compute eligible expenses under the old method. And then for December 9th through the 31st, we'll compute it under the new approved method. Whatever elements are approved for recovery, amortization period, all those items. We'll get a total expense, and then we'll compare it to the revenues. There'll be a difference. Then we'll tack that difference on to our cumulative over under recovery, and we move on. And so when you get to June 30th, 2022, if that's the date we use for tariff PPA rates, then that cumulative over under recovery at that point in time would be folded in to the rate setting process for tariff PPA rates in the upcoming year.
When do you apply deferral accounting to that over and under recovery? Each month or
Every
at the
month.
end of the period?
Every month.
Okay, so the first month you create a regulatory liability of $10. Second month, you reduce that regulatory liability by $5.
That's correct.
And if at the end of it, it goes from a liability to an asset, you have the reg asset on the books at $5 going into the next year, and you begin to amortize that $5 regulatory asset as part of, over a 12-month period, as part of tariff PPA.
We don't amortize the regulatory asset. We continue to do that over under accounting each month. So in essence,
Okay.
as the rates are designed to catch up with the over under recovery, you want your balance, your rider account, your over under recovery and your rider accounts to be relatively small. You want your rates, theoretically and conceptually, your rates are designed such that you're collecting roughly what you should. But either way, the only expenses in your income statement are those that are connected to the revenues that are coming in.
So let me ask you this way. If the year for the proposed tariff that goes into effect December 9th, if it goes through June 30, it's set up to recover half of the $20.4 million fixed cost savings. Right? So whatever savings is supposed to accrue for the last 3 weeks of December will be just taken up in your over and under determination. And the same goes for the amortization expense, right?
I believe it's considered in the rates that customers will begin paying on December 9th. It's not as if we're waiting to, the Kentucky Power was not planning on waiting to implement.
You think the
revised.
calculation includes amortization expense equal to 6 months and 3 weeks?
I know that the revenues that are coming in the door are designed to reflect the 6 months and 3 weeks.
And you're gonna look at the tariff, tell us how that was done? I mean, you said you believe it's in the mechanism, but earlier when I was asking about it, you couldn't tell us exactly how it was.
I can't
determined to-
recall the rate design calculations that take the dollars that are recoverable and transform it into a customer rate to know exactly how, that's the revenue side of the coin. I more live on the, the expense world versus in the rate design realm, but it's definitely something that we can get for you.
And the last thing I just want to make sure, for purposes of what we're talking about, the amortization expense and the fixed cost savings are separate, because all you need is the amortization expense to be included in the revenue. It's unrelated from the fixed cost savings, right? In the sense that you don't have to recognize the fixed cost savings in order to flow through the amortization expense through tariff PPA.
I mean, the two are very much connected in the fact that they were part of the same negotiated settlement in the 2017 base case.
Right.
So,
That's fine.
but from an accounting perspective, in order to amortize the Rockport deferral, GAAP accounting would require me to have an order that provides some sort of evidence that supports that the commission has approved recovery over a certain time period, and then I need to be able to see how that's coming through rates, how it's being collected.
Let me ask it this way. Insofar as you have to match expenses and revenues related to the amortization expense, the $40.8 million are not the revenues. It's just the inclusion in tariff PPA that are the revenues.
That's correct.
The FAC, I just want to make sure, you were talking about PPA earlier, but the FAC, that reg asset, reg liability each month is exactly the same for FAC
We
as
do
it is for
over under
PPA.
accounting for the FAC.
And that's the same for all of your formula, effectively formula rate provisions, the decommissioning rider, everything, monthly regulatory assets.
Monthly over, yes.
Okay. So my only thing that I'm confused about that on is you can set up a regulatory asset for amortization expense, even though it's a non-cash expense?
Can you give me an example?
Well, yeah, amortization expense, like depreciation is a non-cash expense, right?
Yes.
But regulatory assets, I thought, were intended to be used for cash expenses.
You can defer incurred costs. So if we stick with LSE OAT expense, Kentucky Power, in my example, and I'm gonna forget which way it went again, but was under recovered by 10 million. They really paid cash. And so that's an incurred cost. That's eligible for deferral accounting under ASC 980.
Right, but depreciation expense is deferrable?
It meets the definition of an incurred cost, yes.
Under 980.25.1 or whatever it is. Yeah, okay. All right, thank you. Mr. Garcia Santana, do you have any redirected you'd like to ask?
Just a few, Your Honor. Ms. Whitney, just to clarify, and before I enter into that questioning, Your Honor, at this point, would it, your questions that would have required Mr. West to be recalled, have they been addressed, so I don't have to like?
I don't think so, because as she noted, she's aware of the expense side and not necessarily the rates side. And I think my questions to Mr. West are more related to how those expenses are then recovered through the rates, and what they're intended to recover. So I do think I'll have a couple more questions for Mr. West on that front, just so I can understand the mechanics of the actual tariff. And I personally hated to ask Ms. Whitney about the tariff, knowing that she's not the tariff person like Mr. West is.
Understood. So then I'll stay away from that then, since that has been covered. Ms. Whitney, the company has an authorized return on equity, is that correct?
Yes,
Okay, and the authorized return on equity for Kentucky Power in 2023, it's going to be whatever the commission has approved to be the ROE for 2023, when 2023 ends, correct?
that's right, that's correct.
Okay. How is it determined whether the company did earn or did not earn its authorized ROE in 2023? How do we know whether the authorized rate of return on equity was in fact earned?
In the context of the settlement agreement and the 2017 base case, it lays out a formula where we would pull the net income for Kentucky Power, the per books GAAP net income for Kentucky Power for the 12 months ended December 2023, and divide it by the 13-month average per books equity balance, and it would produce an ROE that would be Kentucky Power's actual earned ROE that would then be compared to the company's authorized ROE, and the difference would be the actual Rockport offset.
Right, and to do that calculation, the determination of what was the actual per books earned ROE of Kentucky Power in 2023, that has nothing to do with rate making adjustments, does it?
No.
Just a second, Your Honor. Please. Okay, and just one last clarification on that. The answers that you just gave me were based on how the accounting works and how the methodology is described in 2017. But you're not telling me anything about how Liberty would do any type of accounting for things that they are going to record, correct?
That's correct. I mean, GAAP accounting is a set of principles and rules, and there is substantial guidance, and there is a very robust framework. But there are matters of professional judgment that Liberty's accountants will apply. Just similar to, you know, my team at AEP regularly reviews significant transactions that require accounting analysis and judgment in the context of generally accepted accounting principles. So I cannot speak for Liberty or the judgments that their accounting team would make. Any comments I would have made were general, just broad and conceptual in the context of GAAP versus specific or narrow matters that would require significant accounting judgment.
Right, but within that context and with that clarification, the answer that you just gave me before, which is that rate-making adjustments have nothing to do with what the per books earned ROE of Kentucky Power in 2023 is going to be, correct?
No, rate-making adjustments have no effect on the per books ROE calculation for 2023.
Nothing further, Your Honor, thank you.
I just want to make sure you gave like the biggest disclaimer I've ever, and I've given a lot of disclaimers. GAAP by definition are generally accepted accounting principles. I think I'd already heard today the testimony, I thought it was by Mr. West, that basically GAAP is an objective measure that is just, it is what it is, right? It's, oh, I think maybe it's his rebuttal testimony, so it was a matter of addition and subtraction. I just want to make sure I understand your response to Mr. Garcia Santana is not that you expect there to be a deviation from the way you might do things for GAAP accounting purposes and the way Liberty might. Do you have an expectation that the calculation of GAAP using AEP accountants for 2023, GAAP net income for Kentucky Power is going to be different the way AEP would calculate it versus Liberty would calculate it?
Generally, no. There should be no difference. And Mr. West's testimony, I believe, was more in the context of rate-making adjustments. Like it is simple, rate-making adjustments typically are simple math, matters of addition or subtraction. What I was referring to is, there are matters of professional judgment in accounting, just similar to how other professionals need to read and analyze and reach conclusions based on the guidance that's out there. Accountants do the same thing. And similar accountants, well-educated accountants, can arrive at slightly nuanced answers.
Yeah,
And
There-
I would be, that's why there is an accounting profession. If the answer were plain always, it wouldn't require the level of analysis and thinking. So I would be remiss if I didn't acknowledge that.
well, there's like regulatory accounting, and then there's business accounting, and then there's tax accounting, right? And people have made a whole business out of private letter rulings, for instance, which are basically, tell me my judgment is right or tell me it's wrong. So I just want to make sure I understand, do you have an expectation that there's going to be a difference? Do you have any personal knowledge that there's going to be a difference in the calculation of GAAP earnings in 2023 if AEP had calculated it versus Liberty?
No, I have no expectation. I just wanted to be clear that I represent the AEP service company, and I cannot speak for any counterparts at Liberty.
That's fine. I just wanted to make sure there wasn't something I was missing. So,
Nope.
Mr. Garcia Santana, do you have any more questions?
I don't think that I do, Your Honor. Thank you.
Okay. All right. Thank you for being here with us today, Ms. Whitney. And assuming that Mr. West can answer, we'll take him first, if that's okay, right after lunch. Bring him back, get the answers to his questions, then we can move on to the other witnesses. Is that okay with you all?
Sure.
Okay. All right. Thank you. So, we will take a lunch. We'll go ahead and take a full hour until 1:15. We'll start back here. Hopefully the internet's working and the cameras are working. I'll ask to recall Mr. West. And it's my understanding, Ms. Glass, you all would like to have Ms. Glenn call Ms. Keaton after that?
Yes, that's correct.
Okay. All right. We'll be in recess until 1:15. Whenever you're ready. All right, Ms. Blend, can you hear me?
Yes, Chairman, I can hear you. Can you hear me?
Great, I can. Thank you very much. We're back on the record in case number 2022-00283. I'd like to recall Mr. West now that he's had a chance to familiarize himself with the tariff amendments to tariff PPA that are currently in the Commission's electronic filing system. Does anybody have anything to take up after lunch before we recall Mr. West? Ms. Glass, anything?
No.
Okay, all right. Would you mind then, Ms. Glass, to recall Mr. West?
Sure, the company recalls Brian West.
Mr. West, please have a seat whenever you get comfortable, and you are still under oath. Ms. Glass, do you have any direct, based off of Ms. Whitney's testimony, that you need to ask Mr. West any questions?
I do not. Mr. West had the chance to look at the PPA update that was filed on November 15th and is prepared to answer your questions as best as he
Ms.
can.
Temple, do you have any questions?
No, sir.
All right, so Mr. West, you've had a chance to look at tariff PPA, or at least the proposed amendments in an electronic filing system, tariff PPA, the Commission's electronic filing system.
Yes.
Can you tell me this most direct way? Can you tell me how the savings from the Rockport, how the Rockport fixed savings for the period of December 9th through December 31st, and going forward, starting January 1 and going forward, how those are recovered, those two different amounts are recovered through the proposed tariff PPA?
I think I can. So at lunchtime, I reviewed that at a high level, and looking at Form 1.0 from the filing. And as we had talked about this morning, for the tariff PPA true-ups, the annual filings, there's a June to July historic period. It's filed in August, takes effect in October billing. So we just did one of those, but then the one we did on November 15th took the way we had put it in there was the 40.8 would be recovered, or not recovered. I mean, it would be passed back to customers beginning December 9th through the end of September of 23. That's the normal period of recovery for the tariff PPA. Because the new rates, when we file in August, they go into effect in October, right? So it was designed to pass that back to customers through that period. Now, because it's based on usage, you may or may not get that fully passed back to customers, right, in that period of time. So that piece would be handled in any kind of an over-under accounting like witness Whitney talked about. But the 2.5 or 2.6 that you were asking about in the stub period, we would then, when we make our filing in August of 23, in addition to that over-under piece for the 40.8, we would take into account the 2.6, let's say, and that would be factored into the next 12-month period.
Yes, and I think that was the basis for my questions initially, is the savings, doesn't matter savings to who, but the reduction in costs of Rockport UPA costs as compared to base rates is 40.8 million
Yes.
on an annual basis. And you can do that, divide by 12 for monthly, or divide by 365 and get a rough daily amount. But the amount of savings between December 9th, I just want to make sure I understand, from your answer there, from December 9th to January 1st, or December 31st, won't actually go back to customers until October of 2023.
That final amount, yes, the 2.6.
Okay, so savings so you all will get that cash savings starting December 9th. Right?
Well, the customers would start getting the savings for the 40.8 December 9th.
Right, but they're entitled to 40.8 plus 2.5 million.
That's right.
That's
They
what,
are.
the 40.8
They
is,
are.
I'm not, the 40.8 is the annual amount, that's fine, December 9
Yes.
to December 9. I just wanna make sure I understand, the 2.5 million savings of things in base rates, costs and base rates that are no longer incurred, but are being recovered through base rates. 2.5 million of that won't be credited back to customers until starting October 2023, and then even then, that 2.5 million will effectively be divided over 12 months.
That's right. I mean, that's currently how it was filed.
I'm just wanting to make sure, I'm
That's-
not trying to,
that's-
if my tone indicates a characterization, it's not supposed to, I just want to make sure
Yeah.
that's, okay. So the savings for that 22 days, the filing is the annual amount, but to be collected effectively over 6 months, or for half of it will be recovered, half of the annual amount, right? The 40.8, only 20.4 is anticipated to be recovered through the final, from January 1 until December, or to June 30, right?
Well, I think that it's anticipated that through September, that maybe that entire period, that entire 40.8 would be refunded to customers.
Okay, so so it's your understanding from the proposal, let me ask it this way.
Yeah.
Do you have the PPA update? Where's that located in the record, that Excel spreadsheet?
It's in the tariff filing. I think it's also in the 2020 rate case, post-case file.
Okay. Have you seen the Excel spreadsheet entitled Kentucky Power Company PPA November 15, 2022?
I think the only part that I really focused on at lunch was Form 1 of that. The one that we filed in November, you mean?
Yeah, so there's a summary, and there's Form 1, Form 2, Form 3, Form 30A, Form 4, Form
Yes.
5, and it goes on.
Yeah.
Are you aware of the summary? Have you
Yeah, I
seen the
remember
summary before?
Yes, I remember seeing the summary.
Okay, do you have that available to you?
I don't have it in front of me, no.
Okay. So I just want to make sure. Sorry, Mr. West. And you have Form 1 in front of you?
I do.
Form 1 will be perfect for this, because the summary is just Form 1 compared to the currently in effect PPA, right? The summary one. So PPA Form 1, you have that in front of you?
Mhm.
Okay. Has 14 items on there, is that right?
Yes, it
Numbered 1
does.
through 14? Okay. So the actual non-Rockport PPA costs for the 12 months ended June 30, 2022 is 160.7 million. You see that?
Yes.
Okay. So that's an annual amount, right?
Yes.
So how much of that, when this goes into effect December the 9th, how much of that will have been recovered? October will have been recovered, November will have been recovered, and then you will do your accounting in 8 or 9 days of December will
Right.
be recovered of that 116. The remainder of the 116 will be recovered through September. Is that right? Or
That's
is
right.
anticipated to be recovered through?
Anticipated, yes.
Okay. And I know all that matters to you all is the final number. That's how you calculate the rate. But kind of like the overage and under, you can take all these numbers and divide by 12, and that's the bottom number divided by 12, right?
Yeah.
So then the non-Rockport PPA base rate amount from 4 and 5, is that the amount that's in base rates?
That looks like that number, yes.
Okay, and then the 18.558604, $18,558,604 is that 100% incremental of base amount that's recovered through tariff PPA? Is that how I should read that? That's the first one less the second one?
I think so. Yes. It'd be nice if I could see the math behind it.
Yeah, that's okay. I mean, it's 98 plus 18 is approximately 116,
Yeah.
right?
Yeah.
So then there's the increase in Rockport collections, reduction of amount of Rockport rate-based deferral. That used to be $10 million, right?
Mm-hmm.
Okay. And it's gone now. That's what expires December the 9th.
That's right.
And then there's the Rockport fixed cost savings, and it says December 9, 2022 plus. And that's just the annual amount, right?
That's right.
Okay.
That's right.
So the subtotal of all those, which by subtotal is really just the incremental tariff PPA expenses with a $40.8 million Rockport savings added to it, results in $22.2 million.
Mm-hmm.
Okay. So then that's grossed up by 60.006093. Okay.
Right.
And then there's the Rockport deferral amount to be recovered through tariff PPA December 9, 2022 through December 8, 2027. Is that just a reflection of that's just the 5-year amortization, annual amortization expense, right?
That's right.
That's 13 times 5 equals the 50 plus million deferral and the weighted average cost of capital applied to it, right?
Right. Over that 5-year period. of
Until
the
December 8,
amortization.
2027.
Yes.
Okay.
Yes.
So then there's the estimated Rockport offset amount, and that's what you are proposing to be the credit that you estimate will be your under earning amount as of June 30, 2022. Your 2023 shortfall,
Estimate.
but it's based off of June
That's right.
30, 2022, no actuals.
That's right.
Okay. All right.
That's right.
There's no true-up yet. That true-up would be the thing that happens in February of 2022, correct?
24.
Sorry, thank you,
Yeah.
2024.
Mm-hmm.
And so then you get a positive $13.916 million. Do you see that?
Mm-hmm.
Okay. So that is the amounts, that's the $22.2 million credit, the gross up of the credit, less the amortization expense for the 5-year reg assets over 5 years, plus their carrying charges, and then the current estimate of the close to 22.8 for the shortfall of ROE in 2023, right?
Mm-hmm.
So you've got 13.9, and then up until what date is that 20.956 a collection?
Well, it would be through September of 23.
Okay. When the PPA that was in effect until June 30 finally got billed. Is that right? September PPA revenues are based off of the previously in effect tariff PPA rate. Is that right? Because the new rate starts for October billings.
That's right,
Okay.
that's
And,
right.
and so the $20,956,127 is what was collected during the last full period, last 12 months of tariff PPA, as compared to what was supposed, that I think this is probably what Ms. Whitney was trying to explain to me, and it wasn't necessarily taking, compared to the over-under of what the target revenue was of $20,937,074. They're pretty close.
That's my understanding, yes.
Okay. And so it actually looks like, well, is it that the company over collected by $19,000, give or take?
That's what it looks like.
Okay, and then that 19,000 is just effectively added to the PPA revenue requirement before the over/under accounting.
Yes.
Okay. This is what I'm trying to make sure of, Mr. West.
Okay.
That $13,897,858 will be applied for service. This is, I just want to make sure I understand the proposal of the tariff here. It will apply to service rendered on and after December 9, 2022 through June 30, 2023. And the billings will be effective September? Is that right?
Well, the billings would run through September, and then
Okay.
the new rate would take up in October.
Okay. But I just want to make sure it's December 9 through June 30. Of December 9, 2022 through June 30, 2023.
Yeah, because the historic period that we use is June to July.
Right.
So when we do the next filing in August of '23, we would use the June to July actuals, but the rate that we would put in here would still be collected through September of any given year.
Yeah, I just want to make sure I understand. But it's for rates effective. The effective date that the rate is applied to ends June 30, 2023. For services rendered on and after July 1, what's the rate that will be in effect for tariff PPA?
It would still be, for July, August, and September, it would still be this rate here,
Okay.
because you don't make your new filing until August, but then rates are in effect, the new rates then would be effective October.
October. Okay. So
Yeah.
this 13.897,858 will be recovered between December 9th and September 30, 2023?
Yes,
Okay. Okay.
yes.
And so to figure out a monthly amount, you could just divide by the monthly equivalent of,
It'd be a rough one because
yeah.
of the usage. It's all
These-
based on usage.
the only business that feels like that plenty of people round to the nearest million. So
Yeah,
I get that it's not gonna be perfect.
Yeah.
And then the one thing that's not in this that I took from the bottom of the paper, and I don't know if it says it on yours, is that when it takes into account the cost for tariff PPA, that starting at some point, Kentucky Power will start incurring the replacement capacity costs, right?
yeah, that was on another exhibit.
When will you start incurring the replacement capacity costs? December 9th?
Yes,
Okay.
Yes.
And where are those proposed to be recovered through?
tariff PPA.
Okay. So whatever the annual amount or monthly amount, whatever, that's going to be an increase to the 13,897,000 amount. Is that right?
I believe those are factored into here.
Well, the bottom of the page says that forecasted replacement capacity costs is not included.
On Form 1.0?
Yeah, do you see the calculation at the bottom for demand and energy?
No, I don't.
Does
Unless-
yours just end at line 14?
Yeah, I must just have your line 14.
Okay.
I mean, it says what it says. I don't disagree with it.
Okay.
Your Honor, I think what Mr. West has a copy of is actually the summary of changes to Form 1.0. Now that I am looking at these
You
two
have-
different tabs.
Yeah, do you have 3 columns of numbers or 1 column of
Oh.
numbers?
She's right, I have 3.
Okay.
I apologize, I didn't read. It says Form 1.0, but it does say summary of changes.
Okay. Well, so let's just assume that, and Ms. Glaskin, correct me if I'm wrong, that the second page of that exhibit for PPA Form 1 has double asterisks at the top of the document, which are explained at the below, that says forecasted replacement capacity costs is not included. Assuming that was the case, how does the company propose to recover forecasted replacement capacity costs? Is that part of the proposed tariff filing?
If it's not in here, then it would be included in the next tariff filing.
So you'll incur a regulatory asset for those costs between now and the next filing?
I'm not sure exactly how we would do that, whether it would just be an expense that would be tracked until we include it in the tariff filing.
Well, I just thankfully learned from Miss Whitney that I think expenses don't necessarily just get tracked. They get created into regulatory assets or liabilities any given month.
Well-
So that's why I'm trying to figure out
You-
what treatment is what happens to those replacement costs? Are they gonna be pushed through FAC?
No, they're intended, they're purchase power costs, so they should flow through tariff PPA. So I guess what I'm saying is I'm not entirely sure why they're not included and how they should be tracked accounting-wise, but they should be recovered through tariff PPA.
Have no basis to agree or disagree with you. I just think they're not. It's your old exhibit that says that the replacement capacity costs aren't there, and who can? I guess this is the question: who can tell me where the replacement capacity costs are going to be reflected, or what the amount is?
Well, I know the amount, was documented in that one exhibit. I think it's KPSC 2-6. And they are accounted for monthly in that exhibit. And as I said, I'm confident they need to be recovered through tariff PPA. Whether they're in there or not, they need to be. But if you look at 2.6, that exhibit, attachment, there is a line for forecasted replacement capacity, and it fluctuates by month because, as you know, costs are different by PJM delivery year. So they're accounted for in this exhibit.
Tier PPA is rate sheet 30, is that right? is that tariff capacity charge?
It's tariff capacity charge.
Your Honor, are you asking what tariff sheet PPA is?
Yes.
It's 35-1.
Okay. Do you have any questions, Mr. Glass?
No, I think that clarified.
All right, Ms. Glass, do you have any redirect?
Can you give me one moment, please?
Sure. Would you like to take a short recess?
That would be helpful.
Yeah, we'll just take a recess until, until you're prepared. Until, we'll take as much time as you need, but no later than 2 o'clock.
That's fabulous. Thank
All
you.
right, we'll be in
Thank you.
recess. right, Ms. Glass, do you have any redirect?
I do, and thank you for allowing us a few minutes to regroup. Mr. West, a few minutes ago, the chairman was asking you about, tariff PPA, Form 1, and he had asked about the forecasted replacement capacity cost is not included note. You recall that?
Yes.
Can you please give us some further information on why those forecasted replacement capacity costs are not included in this form?
So, basically what we did is, when we made this filing, we wanted to stick to the way the forms have already been laid out. And there was no line item for replacement, purchase capacity costs. And so we didn't change it. We didn't change it at this point. The thought was that, normally this tariff is, as we've talked about, it's a July or a June to July historic period. And then that's what is recovered over the next 12 months. So at the time that we do our next filing, in August of '23, we will have historic costs for those capacity replacement costs that I mentioned are listed on that attachment to KPSC 2-6, I think. So at that time, they'll be included in that. And as long as they are probable of recovery, from an accounting perspective, they'll be included in the over-under accounting and included in the next filing.
Thank you very much. That's the only question I have.
All right, thank you, Mr. West.
Thank you.
Ms. Blenda's next, correct?
That's correct.
Ms. Blend, can you hear us?
Yes, Your Honor, can you hear me?
I can. You would like to call Kentucky Power's next witness?
Yes, thank you. The company calls Allison Keaton.
Ms. Keaton, please raise your right hand. Do you swear or affirm that the testimony you're about to give is true and correct under penalty of perjury?
I do.
Okay. Please state your name and business address for the record.
Allison Keaton, 1 Riverside Plaza, Columbus, Ohio, 43215.
Ms. Blend?
Thank you, Chairman. Ms. Keaton, by whom are you employed and in what capacity?
I'm employed by American Electric Power Service Corporation and tax regulatory principal.
Thank you. Did you cause a response to a data request to be filed in the record of this proceeding?
Yes.
Do you adopt that response today?
Yes, I do.
Thank you. Ms. Keaton is available for cross-examination.
Mr. West?
No questions.
Mr. Kurtz?
No questions.
Ms. Dimple?
No questions.
No questions.
All right, thank you for being here with us today, Ms. Keaton. I'm glad that we were able to accommodate you and glad we were able to let you testify remotely given our paucity of questions. You may be excused.
Thank you.
All right. Thank you, Ms. Blend. Do you have anything else remotely?
No, Your Honor. Thank you.
All right, thank you. And do you plan on sticking around, or would you like to, not that you necessarily have to ask, but would you like to be excused?
Your Honor, I would ask that Ms. Keaton be excused. I will stick around.
All right, that's fine. Ms. Keaton can go on with her day. Happy to have you virtually as long as you'd like to stay.
Thank you.
All right, we have one more witness. That's Ms. Sanderson. And it's my understanding that Mr. Tillotson will be presenting. Ms. Sanderson, is that right?
That's correct. Are you comfortable sitting there, or do you want me to switch?
No, this is fine.
And Chairman, it's an odd procedural posture because Ms. Sanderson didn't sponsor a data request or any testimony. I don't necessarily have any direct examination for her. We've offered her to be here to answer any questions that the commission staff or the parties might have for her regarding the exhibit that was attached to Mr. West's data request response. So we'd like to offer her to be able to answer any questions, but I didn't necessarily have any direct examination that we needed to go through with her.
Yeah, so it's, well, let me say it this way. My preference would be for you to introduce the witness and also conduct a little direct examination as to why you think that's important and what information she has personal knowledge of relevant to the exhibit to Mr. West's, relevant to Mr. West's exhibit.
I can do that.
Does that make sense?
Yes?
Okay, all right.
Mr. Tillotson, would you tell me, remind me of the spelling name, sir?
Sure, it's, my last name is Tillotson, Tillotson.
Thank you.
All right, Ms. Anderson, please raise your right hand. Do you swear or affirm that the testimony you're about to give is true and correct under penalty of perjury?
I do.
Okay, please state your name and address for the record.
Tisha Sanderson, 14920 West Camelback Road, Litchfield Park, Arizona, 85340.
Mr. Tillotson?
Thank you, Chairman. Ms. Anderson, for the commission, can you state by whom you are employed or you employed?
I am the Vice President of Finance.
Okay. And in your role with Liberty Utilities, will you have an anticipated role with Kentucky Power Company following closing of the acquisition?
Yes, upon closing of the acquisition.
And what will your role be?
I will be Vice President of Finance and Administration for Kentucky Power.
Okay. And Ms. Anderson, as part of this matter that we're on here today, were you contacted by Kentucky Power Company or AEP regarding some information that they requested of Liberty Utilities?
Yes, I was.
And what were you asked specifically to provide?
I was asked to confirm whether transaction cost or transition cost would be included in the books of Kentucky Power upon closing.
And as part of your assistance of AEP or Kentucky Power Company, did you cause to be prepared an affidavit that you provided to them?
Yes, I did.
And is that the affidavit that was attached to the response to data request 3-2?
Yes, it was.
Did you also oversee the preparation of an Excel spreadsheet that was attached with that response?
Yes, I had oversight of the preparation.
And do you have personal knowledge of the information contained in that Excel document?
Yes, I have knowledge of it.
Do you have personal knowledge of the affidavit of all the information that you provided in the affidavit that you provided to Mr. West?
Yes, I do.
Okay. Do you have any changes that needed to be made to that affidavit or to the Excel file at this time?
No, I do not.
And again, you said that you were asked to provide information regarding the transaction or transition cost. What was the purpose of you providing that information?
To confirm that the transaction cost will not be included on the books of Kentucky Power, and then to confirm that the one-time transition cost will not be included on the books of Kentucky Power.
And at the risk of going too far during this direct examination, just provide us a little bit of information of how that will occur, that those costs don't need to be excluded from the books.
They do not need to be, or they will be excluded from the books because they will be captured in work orders and held on the books of Liberty Utilities Co.
No, I don't have any further questions for Ms. Sanderson.
Mr. West?
I don't have any questions for this witness.
Kurt?
Thank you, Your Honor. Good afternoon, Ms. Sanderson.
Good afternoon.
You will become Chief Financial Officer of Kentucky Power upon closing?
I will be the Vice President of Finance and Administration.
Oh, okay. So, transaction costs will be on the books of Liberty are things like investment bankers, lawyers to do the deal, the acquisition of Kentucky Power?
That's correct.
Okay. And one-time transition costs are things like integrating Kentucky Power from AEP to Liberty. Is that correct?
That's correct, in addition to rebranding cost.
Rebranding is considered a one-time?
Yes, it is.
Okay. However, long-lived transition costs, capital investments, will be on the books of Kentucky Power.
Yes, they will.
So what would be some examples of long-lived transition costs, capital costs, that will be on the books of Kentucky Power?
Yes, an example of that would be an ERP system, so that we can do our accounting, a CIS system, so that we can do our billing and collections.
What about a new transmission control center?
At some point in the future, we will have that. At this time, those costs are not known.
Okay. As you're familiar with the commission's approval of the acquisition of Kentucky Power by Liberty?
Yes, I am.
Okay. There were a number of things the commission did, including the $43 million regulatory asset was ordered off the books of Kentucky Power by the creation of a regulatory liability. Is that correct?
That's correct.
There was the establishment of a $40 million fuel fund.
Yes.
The commission ordered that $15 million a year in so-called transmission subsidies were to be eliminated for a total of up to 5 years.
Correct.
Okay. Let's just take the $43 million regulatory liability. That will be a cost incurred on the 2023 per books revenues and earnings of Kentucky Power. The write-off of the $43 million, will it not?
It will be.
Okay. So that will drive down the 2023 per books earnings, moving in the direction of Kentucky Power taking the entire $40.8 million of Rockport fixed cost savings. In other words, as you bring Kentucky Power's per books earnings down, it's more likely that the extra $18 million, which the leftover 40.8 minus 22, would be retained in that 2024 true-up. You don't agree with that?
We'll do the adjustment for that when we do our opening balance sheet entries.
Okay. So you will adjust that off of the per books.
Right.
Okay. Well, isn't that modifying the 2017 settlement agreement? Because the 2017 settlement agreement says use actual per books, and if you're going to adjust it, you're changing the settlement.
It's done in the opening balance sheet adjustments, though.
What difference does that make? You're changing the 2023 per books earnings.
Not for Kentucky Power.
Well, you just said you would adjust it out of the true-up mechanism, so you've adjusted and changed the 2023 per books earnings.
It's going to be adjusted before we start the books for Kentucky Power.
So you will make the adjustment before the transaction closes?
At the same time, that's right.
So the closing will be in mid-January of 2023, right?
That's right.
So why would that not affect 2023 earnings?
That difference will be held at it'll be held at Liberty Utilities Co., not on the books of Kentucky Power.
So why do you need to adjust the books of Kentucky Power?
We're accounting for that in our opening balance sheet adjustments as we set the company up.
You were here, if the commission says we're going to adjust the 2023 per books earnings for various rate-making adjustments, charitable contributions, political donations, advertising, that's changing the per books earnings, correct?
If the commission were to order us to make those adjustments, then we would do that from a rate-making standpoint, but the per book income would remain the same.
But the 2017 settlement agreement says use per books with no adjustments. If the commission says we want to make adjustments, the commission would be changing the settlement, would it not?
I'll have to take that away and give it more thought.
Thank you, Chairman. No more questions.
Ms. Temple?
excuse me, if you could refer back to that spreadsheet that you all were just discussing, but under the long-lived tab, are any of those projects going to begin in 2023?
Yes, they will.
And so, as a post-hearing data request, could you provide the estimate of those expenses that will be recorded on Kentucky Power's books in 2023?
I will respond to a data request, but the timeline for all of those projects are not known.
I don't have any other questions.
Commissioner Regan?
Just to clarify what Mr. Kurtz is asking, so you would take the adjustment before you start the balance sheet?
That's right. We will account for that liability in the opening balance sheet.
Okay, and that liability then is at Liberty?
That liability will be on the balance sheet for Kentucky Power, but not
Okay.
necessarily on the income statement.
Okay, all right, thank you.
Yep.
What does not, I'm sorry, what does not necessarily mean in your answer to Commissioner Regan? Will it be on the income statement or will it not be on the income
It
statement?
will not be on the income statement,
Okay.
just on the balance sheet.
And so tell me how that works. I mean, if a utility has to write off a regulatory asset, which is, I don't know if it's the right nomenclature or not, but write off the regulatory asset, that's a reduction to net income, right?
Yes,
So is Liberty basically giving Kentucky Power at the outset, the opening of the books, an amount equal to that regulatory asset as a regulatory liability, and so they net to zero at the beginning of Kentucky Power's books post-transaction?
in essence, yes.
Okay, and then so now a new expense is on Liberty's books, but for the exact same amount.
That's right.
I want to understand about these one-time transition expenses. I don't, I'm not saying they aren't, I don't necessarily remember those being the universe of transaction and one-time and ongoing transition expenses being defined, the entire universe of those expenses being defined in the sale of Kentucky Power to Liberty from AEP here in front of the commission. But the one-time transition costs, do you refer to those, did you have a copy of your affidavit in front of you?
I do.
So, on paragraph 6, you state how Liberty defines transition costs. Do you see that? And what I read here is that Liberty defines transition costs as the costs to enable the handover of operational control from the buyer to the seller. Liberty further separates transition costs into two categories. One-time transition costs are the costs of staff required to work on the transitioning of the business from AEP to Liberty. IT support and external services between agreement to the sale and closing. Long-lived transition costs are defined as the capital investment to enable day-to-day operations continuity, particularly where sellers retain some or all of the pre-existing systems. Is that right?
Yes.
Earlier, you said that branding was a transition cost. Do you believe branding to be a one-time transition cost or a long-lived transition cost?
Rebranding would be a one-time transition cost.
Okay. So a one-time transition cost per your affidavit here are the cost of staff required to work on the transitioning of the business, IT support and external services between agreement to the sale and closing. Which of those three items does rebranding or branding fall under?
It would be another category.
So you could suspect my surprise when on the stand today you've now indicated to us that branding or rebranding is a transition cost, but not within the definition that Liberty has.
That's correct.
What else is a transition cost from your perspective that is not defined in this affidavit?
I can't think of any others at this time.
How about marketing? If today Kentucky Power has a demand-side management advertisement talking about low-income home weatherization. And it specifically refers to Kentucky Power as an AEP company. Is it your expectation that Liberty is going to continue running that advertisement post-closing?
We would run our own advertisement.
The cost of a new advertisement would be a transition cost or not?
No,
So that would be calculated in the per books determination if the cost has occurred in 2023.
that's correct.
Is that a cost that otherwise would have been occurred but for the transaction of the sale of Kentucky Power from AEP to Liberty?
I believe Kentucky Power still would have run advertising and would have still had that expense.
Oh, they would have had, but they wouldn't have had to shoot a whole new commercial taking out the part that says that Kentucky Power is an AEP company, right?
I understand your argument.
It's not an argument, it's a question. But for the transaction, reshooting that commercial, for instance, wouldn't have to take place. Would you agree?
That's correct.
How long have you been with Liberty?
Over 10 years.
Okay. Have you ever heard a Liberty advertisement?
I have seen the Liberty advertisement.
Okay. So is it your expectation that the cost of Liberty now shooting new advertisements to let folks know that they exist and they're the new folks in town and that, you know, AEP is no longer the entity to contact if you need anything, or that Kentucky Power has new owners? All of those, do you expect those to be on Liberty's books, all those, the cost of all that marketing, or do you expect that to be on Kentucky Power's books?
I would have to take that back to further evaluate the specifics of each advertising campaign to determine if there was a piece that needed to be removed. I'm not sure at this time.
Are you in your experience aware of Liberty having paid for advertisements of operating companies?
Not sure I understand your question.
Well, Liberty runs other utilities in other states, right?
That's right,
And so the advertising costs in those other states, are those held at the holding company or at the operating company?
the operating company.
Okay, so it would be out of the ordinary for Liberty to incur those marketing costs,
Right.
per your experience.
That's right.
You ever visit any of the operating companies of Liberty?
Yes, I do.
Do they wear operating company specific uniforms?
No,
No, they don't have uniforms at all, or they're not branded at all?
we all have the same branding.
Okay, what is the branding, what's the uniform?
Liberty,
Okay, so all of the folks at Kentucky Power, your expectation post-closing, assume everything goes the way Liberty wants it, all the folks that work at Kentucky Power, your expectation is at least consistent with the historical practices that all of them will then need to have new uniforms that have the Liberty brand. Is that your expectation?
yes.
And in your experience, are the cost of those uniforms borne by the holding company or by the operating company for the other Liberty affiliates?
They are held by the operating company, but upon rebranding, that is typically a one-time transition cost, and we would not include that in the cost of service.
Right, but we're not talking about cost of service here, right?
Correct,
We're talking about per books.
yes.
Okay. So new uniforms is a transition cost?
We probably would put a patch over the old logo, and the one-time transition cost would not be held on the books of Kentucky Power.
Okay. So, I guess I'm not clear here then. So, there would be zero cost incurred by Kentucky Power to get everybody new uniforms.
There could be new uniforms just in the normal operating business, but if we had to put a patch over an old logo, that would be deemed a one-time transition cost and not held on the books of Kentucky Power.
Letterhead, new envelopes, all of those things are one-time transition costs. Those are the costs. So how does Liberty pay for those one-time, how do those not end up, if Kentucky Power incurs the expense, how do they not end up in per books Kentucky Power in net income?
Yep, they're held up at a higher level. So they're held by Liberty Utilities Co., and they are not allocated down to the operating company.
So if Kentucky Power gets new envelopes to send bills out every single month, Liberty's gonna buy the first batch of those?
If we're not able to use what's there, then if it was a one-time transition, then that would not be passed down. But going forward.
I'm not asking what's gonna be passed, I'm asking who incurs the original expense. Is it your experience that Liberty will actually be the one that buys those envelopes?
Yes.
And are you aware of any mechanism whereby Liberty, in incurring all of these one-time transition costs, will be reporting or indicating those costs to the commission?
If we were ordered to do so, we would.
Okay. I'm just wondering where, you keeping a list, is there something that we can see where you all are trying to keep track of, this is a transition cost, this is not a transition cost? Well, this is a transition cost, but it's a long-lived transition cost. Where do you all keep that master list if the commission should ever ask for it?
We have work orders set up to capture those costs.
And then finally, do you disagree? I think that the answer I got earlier, like severance packages and things like that. Well, we'll just say severance packages. Severance packages would be included in per books, correct?
That's correct.
Do you define those as being transition costs or transaction costs?
No.
Even if they're exclusively related to the transaction?
No.
And just finally, if you all have to bring in folks, HR consultants, whatever it may be for the timely transition, those are paid for by Liberty, is that right?
That's correct.
And it's not that they're paid back by Liberty, but they are actually on the original expense are incurred by Liberty, is that right?
That's right.
Mr. Tillotson, do you have any redirect?
Just really briefly, Chairman, thank you. Ms. Anderson, a lot of these transition costs that were being discussed, such as marketing or rebranding, are those costs being incurred to prepare for day one of the post-acquisition, post-closing?
Yes.
Are those costs currently being incurred, or at least some of those costs currently being incurred?
Yes, they are.
And for those costs that are currently being incurred, how are they being accounted for?
One-time transition cost.
And at what level, at what company are those being paid by?
Liberty Utilities Co.
Okay. And it's anticipated that those transition costs that are incurred post-closing will be accounted for in the same way?
That's correct.
Okay, that's all I have, Your Honor.
All right, thank you for being here with us today.
Your Honor, I'd like to ask if Ms. Anderson may be excused from the rest of the hearing as well.
Yes.
Thank you.
So Mr. Tillotson, Mr. Garcia-Santana, Ms. Glass, Ms. Blinn, is there anything else from either Kentucky Power or Liberty's perspective that we need to take up with your witnesses today?
No, Your Honor.
Okay. All right, thank you all. We've only been going for an hour, and we did take that 10 or 15-minute break. Is there any objection to going ahead and having the AG and KAUC call their witness now before taking a break?
That's fine. No
Okay.
objection.
All right, Mr. West, Mr. Kurtz, would you like to call your witness?
Mr. Kurtz will be presenting, Mr. Collins.
Okay, thank you, Chairman. All right, Mr. Collins, please raise your right hand. Do you swear or affirm that the testimony you're about to give is true and correct under penalty of perjury?
Yes.
Please have a seat. State your name and business address for the record.
My name is Lane Collin. My business address is J. Kennedy and Associates Incorporated, 570 Colonial Park Drive, Suite 305, Roswell, Georgia, 30075.
Mr. West?
I'll do it.
Oh,
Chairman.
Mr. Kurtz?
Yeah. Mr. Collins, you have in front of you a document marked direct testimony exhibits of Lane Collin on behalf of the Kentucky Attorney General and KIUC.
Yes,
Was that prepared by you or under your direct supervision?
yes.
Do you have any changes you'd like to make to your testimony?
I have two corrections. On page 8, line 4, the reference or the word company should actually read commission. I think that's probably fairly obvious. Page 14, line 5. There are two missing words after Rockport. Rockport, the two missing words are deferrals estimated. So it should read the amortization recovery of the Rockport deferrals estimated in case 2017-00179. Those are the only changes I have.
Your Honor, with those changes, I tender the witness for cross-examination.
I don't think it'll surprise you, Mr. Kurtz. I just ask that you file those as an errata to Mr. Collins' testimony at some point after the hearing, but before submission.
Okay, thank you, yes.
All right, Ms. Glass, are you going to be conducting cross-examination of Mr. Collin?
I will not, Mr. Garcia Santana will.
Mr. Garcia Santana, would you like to conduct cross-examination before or after the commission staff has?
Oh, I will go at your pleasure, maybe after?
Okay, that'll be fine.
Well,
Ms. Dimple?
we actually do not have any questions.
No, I don't think I do either.
See, I usually always piggyback over the questions that are asked before me, so
Yeah.
maybe I should just start it with you, Mr. Garcia Santana.
if-
I've yet to show up with a prepared question in the last year, probably. So, would you like to conduct some
At
cross-examination,
your
Mr. Collin?
pleasure, I can go, and if you have some questions after, that would,
That'd be great. Thank you.
thank you. Good afternoon, Mr. Collin, how are you?
Good afternoon.
Just for starters, would you agree that it has been beneficial for customers that the company cooperated with KIUC, the League of Cities, Kentucky League of Cities, and other parties to provide rate relief to customers during the past 5 years?
I'm not sure I followed that question at all. Are you asking about the 2017 case settlement?
Correct.
Okay. Was that beneficial to customers to
Yes.
defer a portion of the Rockport fixed costs? Yes, it was beneficial.
Okay. Do you recall Kentucky Power being commended publicly by the chairman of the commission in 2018 for working cooperatively with customers to provide that rate relief?
I do not.
Okay. Your Honor, could I circulate a document to try to refresh the recollection of?
Yeah, and do you have a copy of the document for the reporter?
Yes.
Yes, you may.
Oh, thank you. And I'll keep one.
Sure. May I approach the
Thank you.
witness?
You may.
I'll wait a second.
You may.
May I proceed?
Okay.
Mr. Collins, if I can direct you to page 2 of this document, and starting at the end of line 3 with the words, "I want to." Would you mind reading that sentence into the record, and then I'm going to ask you a question about it?
You'd like me to read that sentence?
Yeah, if you wouldn't
Just the
mind.
one sentence?
Yeah.
Okay. I want to compliment Kentucky Power for their willingness to negotiate and for working with their customers to help make rate relief possible.
Does that refresh your recollection anyway from the question that I asked you before?
This appears to be an op-ed. I've never seen this before, but, KIUC, which is one of my clients in this proceeding, was a signatory to that settlement agreement. And we believed it was appropriate. However, the commission did not approve the settlement agreement without modification. And we can discuss that, but it approved certain accounting aspects with respect to the reduction in the base rate increase, and that was a good thing. And the authorized the deferrals, which also was a good thing, but it did not approve the future rate making. That was deferred to the next general base rate case. But settlement agreements generally are good for customers.
Let me turn your attention to see if you agree with the statement at the bottom of page 1, if you may. Would you mind reading the last sentence of the first page, that the ones that's like any business? And then I'm going to ask you whether you agree with that statement.
And this is out of this op-ed by the former chairman.
Correct.
Like any business, if utility companies are forced to provide their services at a loss, the company cannot succeed and consumers will ultimately be harmed when those services are no longer available.
Yeah, thank you. Do you agree with that statement?
I can't agree or disagree outside of a context, because in the case of the Rockport deferrals, there was no loss. There is no loss. There's not a party in this proceeding that is recommending that the company not recover the deferrals. And so within the context of this case, it's not even a relevant statement. There's not a loss on the table for the company. The company deferred. The company will get recovery. And the only questions, as I understand it, are the form of the recovery and the period over which the recovery will occur.
Mr. Cullen, do you recommend to this commission that it disregard the 2017 settlement as to the using the portions of the avoided costs associated with the termination of the UPA to ensure that to the extent that it's necessary for Kentucky Power to earn its authorized rate of return, just as it's set forth in the 2017 case settlement?
I'm not sure I can answer that question yes or no. I will say this, that there's been a very, very material change in the facts and circumstances that really caused the settlement agreement to be inappropriate at this point in terms of the use of the per books 2023 earned return. And that's described, I described that extensively in my testimony, but that's the Liberty acquisition of Kentucky Power Company, which upends the entire cost structure for 2023. Costs have already begun to be incurred by Kentucky Power Company. For example, the termination of the receivables agreement with AEP Credit. That's already increased the cost of Kentucky Power Company. That already has been implemented, and that is a direct result of the Liberty acquisition of Kentucky Power Company. So I really, the facts and circumstances have changed significantly, and I think it's appropriate and necessary that the commission recognize that rather than allow Kentucky Power Company to essentially benefit from that process and reclaim the entirety of the $40.8 million of fixed cost savings.
In 2018, KIUC did not know whether Kentucky Power was going to earn its authorized, approved by this commission, rate of return or not. Is that true? KIUC did not know in 2018 whether Kentucky Power would earn its authorized rate of return in 2023, correct?
In 2023, you kind of dropped your voice. I didn't.
Yes, in 2023.
That's correct, nor did Kentucky Power Company. But no party knew for sure that AEP would sell Kentucky Power. I mean, Kentucky Power had been part of AEP for 70 or more years. And it's such a material change in circumstances. There are transition costs, ongoing transition costs. There are other costs that wouldn't necessarily even be characterized as transition costs, but they're related directly to the Liberty acquisition, such as the increase in financing costs from the termination of the sale of the receivables. You have the net operating loss issue that I raised in my testimony, write-offs due to the fuel adjustment clause benefit, and there are other write-offs, unless Liberty plans on taking those to its bottom line rather than putting them through on the income statement of Kentucky Power. And by the way, that was news to me on the regulatory liability, because we asked discovery on those very points, and the company declined to answer those questions.
Prior to the 2018 order in the 2017 case, do you recall whether Kentucky Power had been earning its authorized rate of return consistently?
Generally, it did not, for various reasons.
And in the period of time between the 2018 order and the 2017 case and the 2020 rate case, is your understanding that Kentucky Power earned its authorized rate of return consistently over those years?
My recollection is that it did not. But that isn't really the point of the inquiry in this proceeding. The inquiry is how to treat the recovery of the Rockport deferrals, over what period of time, and in what manner. Whether the company has achieved its earned return in historic years is not necessarily relevant. What is relevant is what is going to happen in 2023. And because of the Liberty acquisition, it's such a material change in the facts and circumstances that we proposed what we believe is a very constructive solution for the commission, and that is to take the 12 months ending June of 2022, not only as the estimated Rockport offset, but the actual Rockport offset, and be done with it. No true up in 2024. The company's own estimate shows that they expect to fully utilize that $40.8 million, meaning that customers won't get one penny of it. And that was certainly not the intent of the parties when that settlement agreement was negotiated and approved. The settlement agreement was negotiated, and certain elements of it were approved, for example, the accounting aspects of it, with respect to the Rockport deferrals in 2018.
Well, let me clarify something that you just said there, because I think that you just made a statement about what the parties expected. You would agree with me that Kentucky Power, when they made the agreement to create the deferral and enter into the settlement agreement with a provision that said that in 2023 they will be able to use the difference in order to get closer to earning its authorized rate of return if they were not able to do it otherwise. That would have been something that was very valuable to Kentucky Power at the time of that settlement, wouldn't it be?
Well, it was a provision or a term in the settlement agreement, and obviously that would be beneficial to Kentucky Power Company. The problem is that the facts and circumstances have materially changed that basically undo the benefit of the bargain that the other parties had on that, and now Kentucky Power Company, through the Liberty acquisition, will benefit unduly. In other words, it's really the Liberty acquisition that upended that provision of the settlement agreement. By the way, a provision that the commission never approved, because as I said, the commission didn't carte blanche, approve the settlement agreement. It said, we approve the settlement agreement with the modifications that are elsewhere identified in the order. And in the order with respect to the Rockport deferrals, as I mentioned previously, it granted the reduction in the revenue requirement, in other words, the rate increase, authorized the deferrals for accounting purposes only, and then stated the future rate making would be determined in the next general base rate proceeding. And then the commission followed through on that in the 2020 rate case, and it said, listen, we're going to open up a specific investigation into these issues of the amortization and the form of recovery, or the manner of recovery. And then the commission did open up this investigation. So it's been a sequential process. And, but I think that it's very, very clear that the commission did not, and I'm not an attorney, but I don't believe it could have determined with finality the rate making, the future rate making with respect to those deferrals, other than to essentially provide assurance of future recovery in some form.
You would agree that the order that the commission issued in 2018 in the 2017 rate case speaks for itself?
It does.
Okay. Let's get back into that, the record in that case for a minute. You testified in support of the settlement in the 2017 00179 case, correct?
You're asking if I put in testimony in support of the settlement, or what?
Correct. Did you testify live in this commission in support of the settlement?
My recollection is that I put in direct testimony in the rate case itself, and I believe that I was asked some questions with respect to the settlement agreement at the hearing.
Your Honor, could I circulate a second document? And before I do that, I probably should mark the first one.
Yep. Would you like to mark this as Kentucky Power's Hearing Exhibit 1?
That would be the
Yes, the
first,
op-ed.
the op-ed document.
All right. Any objection? All right.
And
So
then
that
the-
one will be Kentucky Power Hearing Exhibit 1.
And the second document that I'm going to circulate is a copy of an expert of the transcript in the 2017 00179 case. And it's the transcript of December 7, 2017.
Is this? Will you be providing the entirety of the transcript or a portion of it?
I only included the portion that has the testimony of Mr. Colling in that hearing, but the rest of the record is, of course.
Right. So I do have one request. I know this is volume 2, and I remember they're very voluminous. Will you please provide by PDF, I know they're on our website, even if it's just to our court reporter, the entirety of volume 2, even if we just refer to an excerpt today during the hearing?
Most certainly,
Okay.
Your Honor.
All
Thank
right.
you.
So we'll mark that as Kentucky Power Hearing Exhibit 2.
Thank you. Mr. Colling, do you have the document in front of you?
The transcript, yes, I do.
Yes. Did you have an opportunity to familiarize yourself, refresh your recollection with it?
I have not. I think it's about 15 pages. If you'd like me to refresh my recollection, I'd be happy to do so, but
Well,
I might need a few minutes to do that.
maybe I can direct your attention to a particular portion, but of course, feel free to review the rest of it. Would you mind turning your attention to page 567 in the excerpt? And then on page, line 23, there is a question that starts, and in fact, and then that goes on. So let me ask you this. Does this refresh your recollection that you offered testimony in the 2017-00179 in support of the settlement?
I'm sorry, the question is this a transcript of the hearing in the rate case, 2017-00179? The answer
No.
to that is yes.
No, the question is whether your testimony was in support of the settlement.
Well, my testimony was addressing a number of the rate case issues, and then there were some questions with respect to the settlement, yes.
Let me draw your attention to page 568 and 569, and I am going to impose on you, sir, but would you mind reading from, actually, I think that I can, since this is public record, I think that I can make this a little narrower. In page 569, did you state on line 5 that it is a tremendous result?
With respect to the deferrals, and I think it's important to get some context here, starting on page 568, line 17. So essentially what we're doing now is we're cutting the peak of the rate increase, and this is through the Rockport deferrals, and then there would be a rate reduction in December of 2022 when the UPEA is either Unit 2 portion of it is not renewed, or maybe the entirety of it is not renewed. There would otherwise have been a very significant rate increase. All this does is mitigate the amount of the rate, a rate decrease. All this does is mitigate the decrease to some extent. So what we've done is you've cut off the peak of the revenue requirement for the next 5 years, and you've raised slightly the revenue requirement over the 5 years starting in December of 2022. It's really a tremendous result. That was my testimony.
Yeah, thank you. I appreciate you doing that. Now, just to clarify, so Kentucky Power agreed to defer costs at carrying a weight average cost of capital for the cost of the UPA at the time, which were pursuant to a federally approved contract, correct? The UPA.
What Kentucky Power and the signatory parties agreed to was a deferral of approximately $50 million over 5 years of the costs that were being incurred pursuant to the Rockport UPA, in exchange for which the company would get recovery of the deferred amounts plus carrying costs at the weighted average cost of capital during the buildup of the deferral period, and then during the recovery of the deferral, as the deferral was amortized and recovered from customers, so that Kentucky Power Company was made completely whole. In other words, they got a deferred carrying cost during the deferral period. They got a deferred carrying cost, again, at the weighted average cost of capital during the amortization period, and they got full amortization of the deferral. And everybody is in agreement, I think, in this proceeding, at least the AG and the KIUC, that the company should get full recovery of the deferrals. The question, again, is over what period of time and in what manner of recovery. And the Commission hasn't decided that. Irrespective of the settlement agreement, the Commission hasn't decided that.
You mentioned that in order approving the settlement in the 2017-00179 case, the Commission's made some modifications to the settlement before it issued the order, correct?
Yes, and with respect specifically to the Rockport deferrals, it approved two components of that. One, the $15 million initial deferral. I mean, this is spelled right out in the order. And then also authorized a deferral of the amount of the revenue requirement reduction and a return at the company's weighted average cost of capital. And it said this is for accounting purposes only. We will look at the rate-making aspects of it in the future rate-making in the next general base rate case order. To me, that's a modification of the settlement agreement. And I think that's borne out by the order in the 2020 rate case, where the Commission again said, listen, we're going to look at the rate-making for the Rockport deferrals. Not in this case, but we're going to defer that to a separate proceeding. And it's all consistent with the fact that the Commission did not adopt the rate-making aspects of the Rockport deferrals that were set forth in the settlement agreement. I mean, it's very clear. It's spelled right out in the order.
The order speaks for itself, correct?
Well, it does, but I mean, I can read, and I think most people can, so.
Do you recall, Mr. Collin, that the settlement agreement in the 2017 case had a provision that indicated that within a certain period of time, a party that considered that modification of the approval by the commission actually could withdraw from the settlement?
I think so. If the commission did not approve the entirety of the settlement agreement, I believe this was a term in the settlement agreement itself, then any party could withdraw from it, but to my knowledge, nobody did.
Right, KIUC did not step away of the agreement as a result of the modifications.
That's right, nor did the company.
Neither did the
Even though the
company.
company did not get the future rate-making authorization that was set forth in the settlement agreement, it didn't withdraw.
Well, the order speaks for itself.
It does, but you're asking me to respond to your question interpreting the order, when it wouldn't be helpful to your position, and that's fair enough, I get it, but I'm just putting the other part of it on the table as well. In other words, if I can interpret it, for your benefit, then I can also interpret it, as I see it.
The customers received the benefit that you called in your testimony tremendous.
Yes,
for-
yes, and nobody disputes that. That's not an issue in this case, and the company's recovery of those dollars is not an issue.
Would you agree that the commission could not have ordered Kentucky Power to defer those costs if Kentucky Power had not participated in the settlement?
I don't know what the legalities of that are in the Commonwealth, but typically the utility has to concur in terms of the deferral on something like this. This is a little bit unusual in the sense that it's not consistent with a recovery clause, like a demand-side management recovery clause or an environmental surcharge recovery clause or a fuel adjustment clause. It's a cost that the utility was going to incur and sought to recover through base rates. And it was entitled to recover that cost unless it was imprudent or unreasonable, and Kentucky Power agreed to the deferrals. And that was a good result. And then in exchange for that, the customers, that the signatory parties agreed that the company could defer carrying costs at the weighted average cost of capital and then recover those costs in the future. And the commission agreed that the company could defer carrying costs at the weighted average cost of capital. And that was a exercise of rate-making discretion. And those provisions of the settlement agreement, the commission explicitly or expressly approved.
Yeah, no further questions, Your Honor.
Mr. Kurtz? Thank you, Chairman. Redirect. Do you recall questions about changing the settlement agreement? Let me back up. You mentioned the termination of the AEP receivables agreement, which is a result of the Liberty acquisition.
Yes, the Kentucky Power 10Q reported, multiple 10Qs in 2022 reported that AEP and Kentucky Power had terminated the receivables agreement, whereby Kentucky Power, like the other AEP operating companies, sold their receivables to a subsidiary called AEP Credit. And those receivables then were essentially financed at a very low-cost short-term debt. And now that means that Kentucky Power has, on average, a $50 million receivable balance on its books rather than selling those receivables to the AEP Credit, and it has to finance the $50 million. So instead of having short-term debt, for example, at 3%, it now has a cost of capital at 8%. So it's more than doubled, almost tripled the cost of financing the receivables. And the Kentucky Power 10Q, the notes of the financial statements, attributed that to the Liberty acquisition. So the costs are already being incurred, even in the 12 months ending June 30 of 2022, related to the Liberty acquisition. That was the sole impetus for discontinuing the receivable sale.
On an annual basis, how much will the termination of the receivables agreement because of the Liberty transaction increase Kentucky Power's expenses?
I estimate roughly on a revenue equivalent basis, $4 million per year.
Okay. So that makes it more likely that in a 2024 true-up, more likely Kentucky Power would get the remaining 18 million that we've talked about because the earnings will have been reduced by 4 million.
Well, sure, that's right. And there are other changes from organizationally, cost structure, things like that that are in process already.
You also mentioned the net operating loss expense as a result of the Liberty transaction.
Yes, that's right. Right now, Kentucky Power Company is a party to the AEP tax allocation agreement, whereby AEP reimburses Kentucky Power for the tax effect of its net operating losses. And under the Liberty ownership, that will no longer be the case. To the extent that Kentucky Power Company has tax net operating losses and has to finance the tax effects of that, that will drag down earnings in 2023. And again, this is one of these costs that would not have been incurred by Kentucky Power or would not have dragged down its earnings in 2023 but for the Liberty acquisition.
Is that a one-time write-off or an ongoing?
It's an ongoing cost. Yeah.
Do you know how much?
I don't know because I don't know what the net operating loss will be in 2023.
In response to cross-examination, you were discussing the write-offs that would occur, and you said you asked Discovery, but then there was news to me. What do you mean by that?
Right.
Your Honor,
I can hear you.
if I may, I was not going to object, but it seems to me that we have gone outside of the scope of the cross-examination at this point.
I'm referring directly to the cross-examination. There was a phrase, news to me, in response to questions from counsel about the write-offs. I think he's referring to the Liberty witness, Liberty Kentucky Power witness, who said they were going to do these write-offs before closing rather than after closing.
That was not part of my cross-examination, Your Honor.
That was the answer.
Well, overrule the objection.
Thank you, Your Honor.
I'd like to hear the full question and the response, and then we'll take it up.
Appreciate it.
He did answer. He did say that in an answer, but I don't know that I got the context of the answer compared to your question, Mr. Garcia Santana.
A little foundation then. In the Liberty acquisition, the commission made a number of adjustments or conditions that benefited ratepayers.
That's correct, yes.
One of them dealt, let's pick one, the $43 million.
Well, we could pick the $40 million fuel adjustment clause benefit.
Okay, $40 million fuel adjustment benefit. Somebody's going to incur, Kentucky Power will incur fuel costs, and they will not get $40 million worth of revenue associated with it.
That's correct.
So that will drag down earnings, will it not?
By $40 million on a revenue equivalent, all else equal, yes.
Per books.
Per books, yeah.
And if you don't adjust the per books earnings for that item, you're essentially taking away, or potentially taking away, part of the benefits that the commission gave to ratepayers in the Liberty case.
Right, the Liberty acquisition case, the commission, I believe, thoughtfully and carefully balanced the interests of Liberty and Kentucky Power and its customers. And there were several harms that the parties identified in the Liberty acquisition case that the commission addressed specifically with either the regulatory liability or, adopting or accepting commitments or conditions offered by Liberty. For example, the $40 million fuel clause benefit, and also address the standalone transmission issue with respect to a contingent $15 million per year potential disallowance. To the extent that Kentucky Power will have to write those amounts off, which I believe that they will in 2023, because only after the acquisition closes would Kentucky Power incur the obligation to effectively refund or not recover $40 million through the fuel adjustment clause. And so these things would occur solely as a result of the Liberty acquisition, and Just those two items, the 40 million and the 15 million on the transmission is $55 million on a revenue equivalent basis. That'll totally eat up the remaining $18 million of, of the $40.8 million Rockport fixed cost savings that potentially were available to customers. And again, but for the Liberty acquisition, those write-offs would not have
But
occurred.
I guess to Mr. Garcia Santana's objection, why was your response earlier that surprises you? The responses that Mr. Sanderson provided.
Well, the thing that surprised me was the regulatory liability for the reliability improvements. And, that somehow or another Liberty planned to address that pre-closing through balance sheet entries. I was very surprised to hear that because the AG KIUC had asked the company specifically with respect to a series of potential write-offs, what they planned to do, or what the company planned to do. And the company responded that we are unable to respond, we don't know what Liberty is planning to do, and plus it's all speculative at this point anyway. And so they refused to provide a response. So now Liberty's witness gets on the stand today and says, well, we're going to do something through the balance sheet. Quite frankly, I don't even know what that is, but normally a write-off such as that would go through the income statement. If Liberty is going to take that essentially as a hit on its purchase, and Kentucky Power is not going to be impacted by that, that's one thing. But again, that's the first time I've heard of that.
One last question, Mr. Collin. Is it your recommendation that Kentucky Power receive $22.8 million of the $40.8 million Rockport fixed cost savings that are currently being recovered in base rates?
Yes, really, I recognize the commission is in a hard place here. First of all, I don't believe that you approved the Rockport offset in the first place. And one of my clients, KIUC, is not walking away from that. But what we are addressing is the substantial change in circumstances in 2023. The Liberty acquisition closing initially was supposed to be in 2022. Now it's going to be 2 or 3 weeks into 2023. And, a lot of these effects would never have hit 2023 but for the delay. And this was at the, due to the circumstances between AEP and Liberty and, their renegotiation of the purchase price and things like that. And it may well have been, as I pointed out in my testimony, it may well have been intentional to delay the closing into 2023. But nevertheless, whether it was intentional or not, and I don't need to make a judgment on that, nor do you, the closing now will occur in 2023, and it will drive down earnings, and it will cause the remaining portion of the $40.8 million that isn't already flowed through based upon June 30 of 2022. In other words, that's $22.8 million, and then there's another $18 million potentially that could be grabbed and then clawed back, if you will, through the true-up. That's pretty definite that will happen. And in fact, that was reflected in the company's response to AG KIUC 2-6, where it did a projection of the rate impacts into the future through May of 2025. And it shows the $18.0 million true-up in March of 2024, recovering $6 million each of the months March, April, and May of 2024 to recoup that $18 million. So, in other words, when all is said and done, the company's forecasts, and I know Mr. West tried to walk away from this in his rebuttal testimony, but that was his data request response that showed that. In other words, they're going to take the entire $40.8 million as an actual Rockport offset. $22 million is going to go in under the estimated, and then the $18 million more through the true-up. So customers will get none of the $48.8 million that they bargained for.
In 2023.
In 2023, that's right. And ultimately, ever.
Or that, yeah.
Uh,
Are
until-
you saying ever they will not?
Well, you know, in terms of the provision of the settlement agreement, they will get the $40.8 million starting in January of 2024 when base rates are reset.
So just, you put a lot of numbers out there. Your position is Kentucky Power should get 22.8 million of the 40.8 million Rockport fixed cost savings, period. That's it, no true up, no attempt to get any of the additional 18 million.
Yes, and I think that's a constructive recommendation. Rather than going to September of 2022, which has more of the costs incurred due to the Liberty acquisition, we don't know what else is in there right now. There's no way really to quantify it, but you know, the $22.8 million for the 12 months ending June 30, 2022, it is known, it is measurable. It's something that you know, it's slightly more than half of the $40.8 million. I think it's fair. If you get into 2023, and I know a lot of the questions from the bench and from the staff have addressed rate-making adjustments to 2023 in the true-up proceeding. And what we're very concerned about is not just a mini rate case, but a comprehensive rate case based upon a historic test year, right on the heels of a real rate case based upon the forecasted test year. So it's very hard to unscramble the egg in 2024 with respect to 2023 because of all of the organizational changes that Liberty is planning to make with respect to Kentucky Power, the changes in accounting, the write-offs, you know, you basically will have to construct a hypothetical test year for a hypothetical utility that did not exist in that form in 2023. So we think we have a constructive proposal on the table. You know, we think it's equitable. It provides the company an offset rather than nothing. And we think it's a good path forward.
Chairman, no more questions.
Mr. Garcia Santana, do you have any questions?
Your Honor, the only thing that I think that is remaining is to move the admission of Exhibits 1 and 2.
Okay, no, but no additional cross?
No additional
To
cross.
give you an opportunity. Okay. All right, we will, Kentucky Power hearing exhibit number 1, the op-ed, and number 2, the,
Excerpt,
thank you, the excerpt, but I would ask that it be
and it will be submitted, the full volume 2,
preferably electronically.
and PDF.
That way she can put it straight. It's preferably, yeah, the PDF would be great.
Thank you.
Thank you.
So those are admitted.
They are, yeah, I'm sorry. Yeah.
Thank you, Your Honor.
Anything else, Mr. Kurtz?
No, sir.
All right, you can be excused, Mr. Collins.
Thank you.
Okay, Ms. Glass, Mr. Kurtz, Mr. West, talking with staff at our last break, we will have a handful of post-hearing data requests to either Kentucky Power or to Liberty. I think that, well, I'll just tell you, I haven't told them, but I'm gonna have some questions about what the universe of transition, one-time and ongoing are, so that there's no reason to continue to leave these things open for further determination and confusion. So that question will be directed to Liberty. We think we can have we will have questions entered tomorrow. Will you all be able to provide responses to those by Friday?
Yes, Your Honor.
Okay. So those will be entered, we'll try to get that before lunch if we can, but we'll have the post-hearing data requests out. I forgot what month it was, 25th, Friday. Okay, so we'll have them out by by at least close of business on Tuesday, the 29th, to be responded to by Kentucky Power and Liberty by December the 2nd. So, Ms. Glass, would Kentucky Power and Liberty either individually or jointly like to file position briefs or legal briefs before the submission of the case?
Yeah, we haven't discussed with Liberty, but I know Kentucky Power would like the opportunity to file a brief.
That'd be fine. So if you all want to, then we'll give the opportunity for all parties to. There's not enough time for anybody to file responsive briefs, but I do think it's important for people to be able to provide their position on the case. The cross briefs are less useful than I know they are work sometimes. So I think that it would be important, though, to give all the parties an opportunity to at least file their position and to provide legal support for any of their positions. I think we have to enter, and the UPA expires on the 8th, is that right?
Yes.
So I think we would have to enter an order at least on the, I'm gonna take the, I think, if we enter an order on the 9th for rates effective on the 9th, is that possible? Have we done that before? Entered rates that are effective the day the order is entered?
Yes.
Your Honor, I'm not sure that we'd be able to implement the,
If we, with the order entered on the 8th then?
yes.
So the order has to be entered on the 8th.
You'll be able to change the rates if the order's on the 8th, right, to the new rates versus the 9th, or to you back there?
I'm sorry.
Okay.
We still need to file
Yeah.
VA forms, right, and have that
So-
stamped
so-
as well.
Okay.
We will,
Okay.
yeah, so we'll enter the order effective on the 8th, and then you all have the 20 days to file the conforming tariffs if they're different than what's proposed. I mean, that's what we usually do at least. Yeah.
I think that works, yeah.
Okay.
Does that work, Larry?
The tariffs will have an effective date of the 8th. So we will enter the order by the 8th, in this case, or on the 8th. That's what we normally do with, yeah. I mean, that's what we do for a rate case, for instance. We have the rates on in effect on and after the date of the order with tariffs to be subsequently filed within 20 days.
Okay, that makes sense.
So, but I don't see any reason that that would be the same case. The effective date of the tariffs would be the date of the order, or whatever the order says. So we would need to enter the order on the 8th. So how about post-hearing briefs on the 5th?
That works for us, thank you.
Mr. West, Mr. Kurtz?
Yes.
So it'll be submitted evidence ending on the 2nd. Briefs on the 5th, submitted at 12:01 on the 6th. Okay. Is there anything else, Ms. Glass, that we need to take up post-hearing from the company's perspective?
I do not believe so.
Mr. Tillotson, anything from Liberty? No. Mr. West? Mr. Kurtz?
No, you're on.
Ms. Temple?
No, sir.
Okay, so, how efficient we were today. Everybody gets a free day tomorrow. I'm sure nobody has anything else to do. So we will get the post-hearing data request entered by tomorrow. You all can have the briefs to us by the 5th. We will venture to have an order by the 8th. Okay?
Great, thank
All
you.
right, if nothing else, this hearing is adjourned.